Everybody. My name is Lee Stokes and I'm a vice president with Vesta Property Services. We are here this morning for our, I think our last board certification class of 2020, maybe. Ed, I don't know if you have any other scheduled between now and the end of the year, but for those of you that are familiar with me and Vesta and also with Ed, you know that we like to do these classes at least twice a year, and then we have our legislative update during the summer months. I'm very grateful that we've been able to continue to do this type of educational seminar series, even through COVID. We've had to learn how to do it virtually, and I think we've expanded our attendee base. Ed and I were talking about that a little bit when we first got started. So at any rate, those of you that know me and know Vesta, you know that our corporate office is located in Jacksonville, Florida. We've been in the industry for over 30 years, and we have regional offices all over the state. I think we have folks attending from all over the state this morning, and that's exciting. If you're a current client, thank you very much for being here this morning. And if you're not a current client, we'd love to talk to you about that. So that's my little plug, had to get that in at the very beginning. I'd like to introduce to you my very good friend and colleague, Ed Ronsman. Ed and I were talking about how long we've been doing this together, and we agreed that it's been about 12 years, I think, since we started this educational series, and it's just gotten bigger and better. Ed is a partner with McCabe Ronsman, which is a statewide community association law firm, and they represent hundreds of condominium and homeowner associations across the state. Ed is a shareholder in the firm and has been representing community associations since he began practicing law 12 years ago. I believe there are 8 attorneys in the law firm, 3 of which are board certified specialists in condominium and homeowner association law. So Ed is our presenter this morning. He is your expert in all things COA, HOA. And with all that being said, I'm going to turn it over to you.
Thank you, Lee. Well, thanks again. For those of you that have attended before, Vesta does an amazing job of continuing to provide continuing education opportunities for board members and new board members, whether it's the board certification class or a legal update or more specialized, shorter courses on fining or collection strategies. We had a series of COVID-19 updates, in the spring when everything started happening, and we were all kind of in the same uncertain boat together, which I think we all kind of still are right now, which is, what should we be doing with our community? What should be open? How are we having meetings? And I'll talk about some of that, because I think that as it's gone on, it's kind of shifted to some more questions about trying to have annual meetings and whether it's safe to have people close together again, that kind of thing. So thank you, Lee, for asking me to continue to provide this. And thank you to all the board members that are coming in. It's a testament to your commitment to your community that instead of just signing off on a little certificate saying that you're going to abide by the governing laws and your governing documents, that you're going to listen to a lawyer talk for 2 or 2.5 hours. It's a lot of material that we're going to get through today. But I appreciate you coming in, and for all the, what I call the repeat offenders. I know that we have some of you on here that are existing board members that come back. Also, thank you for attending. I think that the comments that I've received are, maybe the last time I took this, I kind of glossed over this, but then this became an issue in our community, and so it has some more relevancy. And so thank you also for attending. A little bit just for housekeeping of how I like to kind of handle this. This is a webinar format, and so the best thing that you can do for questions is when you look at the bottom, there's a Q&A button down there. If you can type out your question there, I believe there's a way you can either make it public to everyone or private just to us as the panelists. Either way works for me, but I will see that and then I'll answer it, and then it helps me go through kind of the queue of how we're going to handle it, and that'll allow us to get through the questions. I'll try to take a look at them from time to time and see if I can answer them when we're on a specific topic, but if we're kind of running behind, maybe I'll hold those to the end. And usually we have like a Q&A session where if you have any other questions that came up, we're happy to answer them at the end. But please feel free to ask any questions, and we'll try to get to as many of them as we can. So with that, I'm going to share. Oh, the other thing too, when you see it up here, it says that we're recording right now. I know that I'll be providing this over to Vesta, and they'll be able to make that available, Lee, I think on demand, or maybe through the website. We'll work with Kevin over at Vesta to make sure it's available. So if you have anybody here that couldn't make it, or maybe they're an existing board member, but would like to view this, I know that we'll be able to make that available for them.
Yeah, we'll make sure to have this available on our homepage, as well as being able to download and send out copies for anybody that would like to have it.
Great. All right, so I'm going to share. We're going to have a PowerPoint here. And if you'd like, at the end, what we will do is if you want to email me, we'll be happy to provide you with a copy of the PowerPoint afterwards too. You'll also, everybody by signing up will receive a certificate. I think I saw a question come in. When you take this course, you'll receive a certificate that will cover you for as long as you're a consistent board member. If you jump off the board for a year or whatever the case may be, and then you come back on, you are required to either retake this course or sign that document that I mentioned before. But for as long as you're a continuous board member, by taking this course, you're going to satisfy that requirement. All right, so everybody should be able to see the PowerPoint here. So some of the topics and objectives, we're going to talk about operations, elections, financial issues, including financial reporting, budgets and reserves, and then official records, maintenance and access. I'm sprinkling in some of the legislative updates that we've seen over the last couple of years. There wasn't really anything this year or really in the last legislative session, but I anticipate we're going to have a pretty active 2021 legislative session, especially regarding emergency powers in response to COVID and kind of further clarifying what emergency powers the association may have. So kind of stay tuned for that. And we provide updates as to kind of what's going along. If you want to check out our website, we have a blog that will update that as necessary. And then we teach a legal update course. I know we would teach that with Lee and Vesta. The objectives for today, we want to increase your knowledge of your duties and obligations in the applicable Florida statutes. Want to define the role of the board. What are your legal obligations as a board member? Association protection issues, and then association problems and issues that may arise. So for operations, so first thing, let's talk about your governing documents. You have your, basically, you have these 4 sets of documents, really with rules and regulations. That can also include what I would call your architectural standards. But your highest priority document is your declaration. That can be called your declaration of condominium, your covenants, conditions, and restrictions, your CC&Rs. They all have kind of maybe different names, but it's all the same document. That's kind of that's your main document that you're looking for. That's especially going to talk about maintenance responsibilities, being able to assess owners. What are your use restrictions in the community? What can you do with your property? When do you have to go and get approval for certain things? What property is covered by the covenants? All that's going to be contained in your declaration. Your articles of incorporation, those are filed with the state. That actually is what establishes your association as a corporation, not for profit. I'm sure probably all of you on this call are corporations, not for profit. That's pretty much all we represent hundreds of community associations, and they're all not for profit corporations. That tends to contain a little bit more from a corporate standpoint, the makeup of the organization, what corporate powers you may have, the number of directors, that sort of thing. The bylaws are similar to the articles, but they'll contain more procedural requirements in terms of notice requirements for meetings. Further, maybe that might define the number of directors or how you can expand the number of directors, the officers, and how elections take place, the use of proxies. So more procedural with the board and the association itself as a corporate entity and how it functions. Usually you don't contain any type of use restrictions in your bylaws. So a lot of you, maybe if you're new to the board, you say, well, our bylaws don't allow us to do that. The bylaw is actually more of a corporate procedural document. It's your declaration that you might be referring to when it says, let's say for a declaration of condominium, and if you have pet restrictions in there, if you say our bylaws don't allow you to have a pet greater than 50 pounds, it's probably more actually your declaration that contains that. And then your last document, it's your rules and regulations. Also include that, like your architectural standards if you're in an HOA. Rules and regulations are typically established by the board. You need to look at your governing documents. You have to have authority in one of the higher priority documents to be able to establish rules and regulations. I'd say 95% of the communities I work with have some type of language there. And the rules are kind of meant to work with the declaration, where you don't want to have in your declaration, for example, putting your pool rules in there in terms of, well, we're going to allow you to, from 8 a.m. to 8 p.m. Well, what if you want to modify that to say sunrise to sunset or something like that? Those are typically things that you don't contain in your declaration, because to change that would usually require a member vote. It's typically then that you establish these rules and regulations regarding common area use, other things regarding that might not be, that you want to have in your declaration, because you want to have a little bit of flexibility to amend them from time to time. So the biggest thing here too is that this is by descending order of authority. So your declaration is your highest priority document, then your articles, then your bylaws, and then your rules. Well-drafted documents, there isn't any conflict between the two, but it's not uncommon to have, an amendment where they maybe didn't reference one over the other and they tried amending a lower priority document that might conflict with the higher priority. You always need to look and see what's the higher priority document. And if there's a conflict, then it's a higher priority document that's going to control. So that's why it's important just to know how your documents work together and what provision should be amended, for example, to make sure that it's going to be actually be able to be upheld. The association must establish a budget, set aside funds for future maintenance, collect assessments to pay for common expenses, and then enforce its rules and regulations. The last point is one I like to kind of focus on just a little bit, in that you as board members, you're going to be faced with owners that are going to want you to enforce what they believe to be a violation, when in fact the board may find that to be no, we don't think this rises to the level of a violation. We think they're still within what they're allowed to do with their property. A lot of times that comes up with maybe, I actually just received an example of this, where an owner is going around taking pictures of their neighbor's property saying that this is not being maintained in a neat and clean condition and you need to send violation letters. Well, neat and clean condition can be very subjective, and the board may not agree that it rises to the level of needing a letter yet. But you're going to have owners that are saying you need to enforce the rules and regulations, you need to enforce our covenants, and if you don't, we're going to sue you for it. The board has what's called the business judgment rule, and that as long as the board is acting reasonably and acting within its authority under the governing documents, courts are not going to second guess the decision-making authority of the board. You would have to act way outside of what a reasonable person or entity would do in order for a court to second guess your decision making there. And usually it comes down to there's gross negligence, or if there's an improper personal benefit. So aside from that, you're going to be protected in your decision making, and a lot of that comes into whether or not there's a violation of the rules and regulations. Now, that being said, you want to make sure that and this is actually going to the next slide here, you want to make sure that you act fairly and equally. That's under protecting and ensuring the interests of the association at large, avoiding personal gains, and acting fairly and equally. So if there is a covenant violation for one property, and maybe it's your neighbor, one of the board members' neighbors, you need to make sure that you're being fair to everyone else, because if you're not, one of the most common defenses in a covenant enforcement issue is selective enforcement. And that's saying, you're treating me differently than somebody else. So that's where, if you are going to enforce something and there is a violation, it needs to be enforced equally amongst all owners. So you need to maintain the common area interests. So obviously, if you've got common area, you've got amenities or just the landscaping, that it's the obligation of the association through the board to make sure that that's properly maintained. And then you want to promote rather than diminish all the common area interests. The big thing is just making sure, what I've seen come up is owners complain about, well, this board, maybe some of the board members, this actually came up in a community where the hot tub broke down at one point for the common area pool, the pool area, and there's a hot tub there. And none of the board members really like using it anyways. And they're like, well, this is kind of a pain and we don't really like it, so we're just not going to fix it. We're going to let it be out of order. There's an argument there that the board is abrogating its duty to maintain the common area interest. So if you have something, it needs to be maintained. If you want to get rid of it, there's mechanisms to do that, but it's kind of like the indifference could be where the board could get in trouble on certain things. So just be mindful of that. All right, so I have a slide here on insurance and construction issues. Obviously, I want to say that we're through the hurricane season, but as everybody knows, we just had that storm come through, and it seems like the season has been extending much longer this year. My 9-year-old is, I think, a future meteorologist and tells me daily if there's a storm brewing anywhere else and if we should be worried about it. So I feel like I'm on top of everything with it. But once we especially push through this, I like to let board members know about it so that you're properly protected when we get into the next storm season, especially. So some insurance clauses that the association should be aware of. You want to have law and ordinance to policy limits. What that means, especially if you're in an older building, whether you're in a condo or if you're an HOA that has a clubhouse or amenities that are being insured if they're older, law and ordinance to policy limits means that maybe that building wasn't it was constructed to code previously, but that the code requirements have changed, and that if there needs to be a reconstruction, to put it into its previous place wouldn't comply with the current building code. If you don't have law and ordinance to policy limits, all you're going to get is the money to bring it back to what it was before rather than bringing it up to code. So you want to make sure that you have law and ordinance to policy limits so that you have the money to actually bring it up to code. You need to have a wind-driven rain endorsement. That's a big key, of course, from any type of a wind-driven rain, a hurricane issue that maybe it's not a result of flooding, but you've got wind coming in and then water coming in through maybe roof issues or window issues there or sliding doors. You want to have proper coverage of all your structures, including signs, light posts, dog houses, et cetera. Everything needs to be scheduled. The biggest thing is don't try to save on your premium by underreporting. And that goes into the co-insurance penalty issue next. Make sure that you're properly covered. Whatever that little increase is in your premium, it's going to make up for it if you actually have an insurable event to make sure you get the appropriate money to repair everything. Co-insurance penalty basically is for kind of making it a simple example. If you have $1 million structure, but you only report it as being an $800,000 structure, that's a 20% difference. If there's actually an insurable event on that, let's say that there's a catastrophic loss and it's a total loss, and instead of getting $1 million for the structure itself, you only reported at 800,000, you're going to get a 20% reduction as to what you're actually going to recover on your insurance claim because you underreported it. So you want to make sure that you're properly reporting the value of all the structures. For condos, there is a requirement that you actually have that done, I believe, every 3 years, where you go and make sure that you're properly insuring your property there. And then the last thing is you need to have replacement costs on everything. That's actually the requirement in the Condo Act. Replacement costs versus actual cash value is the value of the property less depreciation. Replacement cost is what would it cost to actually fix this, to bring it up, to make it brand new, basically. So you need to have replacement costs. Otherwise, you're going to be losing money on any type of claim because of depreciation there. You need to bring insurance claims within 3 years generally. Flood claims are different. That's a much tighter time period. But for any type of something from like a storm event that's not flood related, you generally are going to have 3 years to bring that claim. Construction defects, this applies mainly for newer construction, but also if you've done a big restoration project. I know a lot of oceanfront condos that I've worked with, if you have an oceanside or a balcony replacement or restoration, that those can be, very expensive projects, roof replacement projects. You can bring construction defect claims on behalf of the association. Condos especially have a clear right to do that. Townhomes, if you're a townhome association here, if the association has standing, if you're maintaining the roofs and the exterior components of buildings, you also have the ability to bring claims. There's a statute of limitations of 4 years from when you knew or should have known of an issue. But a lot of construction defects are latent issues that you don't know about that might be behind. Let's say if you've got stucco or siding, and if you've got any type of wood frame, especially there, that you might have rotten wood, but you can't see it from the front. That's where really the statute of repose comes in, that says that regardless of when you became aware of it, you can't bring it later than 10 years. And there's a couple of different trigger points, but for new construction, the most conservative way to look at it is when the certificate of occupancy was issued for the building. For like maybe restoration projects, it's really, you're probably be looking more at the completion of the contract and going 10 years from that date. So know that you have a time limit. But 10 years is kind of the drop dead date. So even if you had no reason to know, and all of a sudden 15 years later, you decide that you find through maybe some type of invasive process for a repair that there's all this rotten wood, you're outside of the time period to bring it. So make sure that you're on top of it. Our law firm, we actually look at that at no cost for associations. And we have experts that we work with that are willing to do that on a free, initial visual inspection. And it's better to look at it up front before you miss your time period, even if you maybe haven't had that many issues, because a construction expert might say, hey, you might have limited issues now, but the way they constructed it was improper. And if it's not fixed, you're going to have a ton of problems down the road. So it's always important to stay on top of that for your community, whether, again, if you're new construction or if you've had a big project done, window replacement, roof replacement, or balcony replacement, that kind of thing, just to make sure that you're on top of the time frame there.
Hey, Ed, can I jump in here with a quick question? And you may cover this later, and I apologize if I'm getting ahead of myself, but we had a company that we work with that does reserve analysis tell a condominium association that they don't have to do a reserve study. And I thought that COAs, not HOAs, but COAs were required to have a reserve study, or they must waive it. Has that changed?
So it's you don't have to, there's no statutory requirement for an actual reserve study. What you have to have
Okay.
for condos is and maybe they're confusing it with the inspection that has to take place to make that you're properly insuring the condominium. That is a
Okay.
statutory requirement. The reserve study is it's not required, but you do, the only way that you can really know that you're fully funding your reserves, which we'll talk about later, is really relying
Okay.
upon that reserve study. I joke about, like, I had to research this in other states, like in California. My joke is that the reserve analysts out there have a great lobby because it's in the statute that says you have to have a reserve study done every year, except that really it's every 3 years that it's a more substantive one, but you have to have an update. So they must have a better lobby out there to have that in the statute than what we have in Florida.
Okay.
Yeah.
Thank you. I appreciate that.
Yep. Yep. All right. So some of the board responsibilities: you want to act as one unit to set your policy, enforce your governing documents, maintain the value of the property, conduct board and annual meetings, set goals for the association, and then maintain the association's financial stability. Some of your legal responsibilities. This is where we come in, and I'm sure a lot of you, especially if you're a new board member, have questions about, hey, I'm a volunteer, can I be sued as a board member? And that's where I'd like to kind of focus on that here. My response has always been, if you've attended these before, you've heard this, is that yes, you can be sued as a board member, but it's very difficult to be successfully sued. So anybody can be sued for anything at any time, whether or not it's a successful lawsuit. For board members, you really have to show that you breach your fiduciary duty to the association. And really, that would have to show that you acted so far outside of what a reasonable person would do, or that you did something that was clearly in your own financial, your best interest, that you didn't disclose that and go through the proper approval with your rest of your board, that's where there could be some liability as a board there. Beyond that, though, it's difficult to be successfully sued as a board member. That being said, you do have a fiduciary obligation. It's the highest. You're deemed to be fiduciaries on behalf of your members. And what that means is it's the highest duty afforded by common law, is to have a fiduciary obligation. And that duty is to act for someone else's benefit and to act in the best interest of the association and its members. You must act with good faith, diligence, care, and skill. You have a duty of loyalty to the association and the members, duty of ordinary and reasonable care, and then a duty of confidentiality during and after your term of service. So probably the biggest thing that I like to focus on here is the duty of ordinary and reasonable care. What that means is you don't have to be right on everything that you do. You don't have to always be perfect on your hiring or on your budget making process or whatever the case may be. The biggest thing is that you're acting as a reasonable person. So competitively bidding, relying upon the professionals that you work with, making sure that you work with appropriate professionals. For example, working with management that they have a license and they have continuing education requirements. The managers do, that they work on behalf of your community. And then hiring, so of course, hiring a good management company, working with a CPA, working with an attorney that, hey, this is something that needs a legal answer. We need our attorney, and then we're going to rely upon our attorney's advice. There's all kinds of professionals that you work with. And as long as you can show that you went through the appropriate process and relied upon them and then acted as a reasonable person would, you're going to be good to go as a board member, in my opinion. It's very difficult, again, to be successfully sued. Now, that being said, in terms of from an insurance requirement, we talked about insuring the buildings. The number one thing that I would want to make sure of if I was a new board member is making sure and talking with my insurance agent that we have appropriate D&O coverage. What is the D&O? Is directors and officers liability policy. That protects you so that if you as a board member are named in a lawsuit, that you then are able to file a claim with that policy, and that you will have defense appointed for you, defense counsel, so that you're not paying out of pocket if you happen to be sued. None of you are getting paid to serve as board members. And so the last thing that you want is to not have a robust D&O policy that makes sure that it properly protects you so that you're having to, defend yourself out of pocket. Nobody would ever want that. And you want to make sure that you have appropriate coverage. Almost every community that I work with has appropriate coverage there, but you still want to make sure, talk with your agent, just say, hey, are we good? Is there anything that you maybe recommended to the previous board that they didn't do that you think we should look at so that we're properly covered there? So that's the biggest thing that I would recommend. Building community, you want to become community involved, seek a positive resolution to community and member issues, emphasize reasonable living and respect, Create healthy relationships with renters, and then establish committees. You want to seek win-win solutions on member issues. I know that things can become contentious, but try to do your best to work with owners that maybe don't understand the decision-making process, to let them know how much work you put in as board members. And honestly, a part of it is to let them know that, hey, we've been elected. You need to trust us. If we've been elected to serve as board members, you need to trust the process and let us do our job. That's part of the process too. Community involved can include not only your neighbors, but local government. If there's a development going up, or if there's an issue in your local government that might be community focused, and having some type of a response provided on behalf of the community, that can be part of it too. You want to have healthy relationships with renters. There's kind of a stigma attached with renters, especially in condos or in townhomes, that they're bad people to have. And that's not necessarily the case. I think it's just a matter of educating them as to, what the community rules are, kind of having them buy into being a member of the community and not just somebody that's there temporarily. The more that you can make renters feel at home and part of your community, I think the better that they are, and they're going to treat it like their home, and make sure that they stay within the governing documents and the rules and regulations. And then finally, establishing committees. I think that that's very important in a lot of well-run communities and boards that I think do a good job on behalf of their associations and aren't getting too stressed out by it. Those are the boards that have tapped into the experience of homeowners in the community that might not want to serve on the board, but want to help out in some way. And that's through establishing committees. And that can be a finance committee. Maybe you have budget season coming up and you don't have anybody on your board that's really gone through a budget making process or isn't all that comfortable with it yet. And maybe you have a former board member that didn't want to run for the board again, but obviously has gone through the budgeting process, and they might want to serve on a finance committee to help make some recommendations to the board. You might have a social or lifestyle committee to help, with some community events when it's safer to have big community events, right, outside of COVID. You're going to have a violations committee, whether that's inspecting violations. That's a separate committee from the what I call the enforcement or the fining committee, which seeks to whether or not they're going to approve fines that have been approved by the board. You might have a security committee or a access control committee, is what I like to call instead of security. A covenants committee if you're thinking about rewriting your documents. So again, have committees in place. What their job is, it's not to make decisions on behalf of the board. It's really to kind of do some of the legwork and then make recommendations so that the board, you're not spending all that extra time on top of what you already do in making policy decisions, that you're not also doing all the legwork for it. So really try to tap into that. Some of the responsibilities for the board is responsible to make decisions and to set policy. You must reach a consensus on policy and direction. For management implements the board directives, works with the board president to fulfill the policy of the board, and then management serves at the pleasure of the board. You want to have good communication with your management company, right? They're an agent that's acting on behalf of your association. So you want to make sure that everything that you're doing there, that there's a synergy and that everybody's on the same page. You want to have a shared vision between the board and the community manager. Board and management should agree on expectations, of course. Understand the difference between setting policy and directing operations. I won't ask Lee to comment on this. I know we have managers on here, but I'll speak for them sometimes, which is, I know that a lot of times management is saying, hey, this is our job. This is my profession. Just trust me. I've got this. Okay. Let me know what you want big picture wise, and then trust us to carry that out for you. If we don't do a good job in carrying that out, you're well within your rights to look for another management company. So the biggest thing though, is letting the people that you've hired do their jobs. And that's the biggest thing. The biggest thing, one of the things I see for boards where their meetings take so long, or that there can be some, I guess, tension within the community, is where the board is spending too much time, not only establishing policy, but then trying to get into the day-to-day operation and guiding every single thing from a day-to-day standpoint. That's when you're getting too bogged down in the details, and you have to be able to rely on people to carry out that policy on behalf of the board. Trust me, when you start doing that, you'll find your board meetings that maybe might take 3 hours because there's so much back and forth and the board's trying to get too much in the weeds on certain things. Try to get those board meetings down to an hour, and we'll talk about board meetings in a little bit. But I think that's a big discussion regarding setting policy and directing operations. You want to have action lists and monthly reports with your management. That helps kind of have a routine and knowing what to expect at each meeting. And I think that creates some accountability to follow back up and say, hey, at the last meeting, you asked me to look into this. Here are all the things that I've been working on. And then obviously you want to have mutual respect. That's a key for any type of relationship there. The other thing too, just talking about policies, I have a note on this to bring it up. Some policies you might want to think about from a board standpoint are having a collection policy. I'll talk about that later, but that really helps guide your management company on, all right, if an owner is this far behind, we're going to send this letter on this date. If they still don't pay, then we send this letter out. And having that, I think it helps with the day-to-day and kind of the flow of the operation so that there's not any second guessing or miscommunication or having to wait to the next board meeting. That's an example of a policy, maybe a fining policy or an enforcement policy that can help provide clearer direction. So having that in place so that then the management company or maybe your day-to-day officer know what they can do and take forward without the board needing to get involved, again, helps with the operations of the community. So some board member roles and responsibilities. You as board members, your homeowners elected to serve by your peers. You're responsible for the conduct of business and delivery of service to the association, subject to the governing documents and applicable laws. So we talked about the governing documents, the applicable laws. I just want to make sure we're all on the same page for that, especially if you're new board members. For condos, you're subject to what's 718 of the Florida statutes. That's Chapter 718. It's the Condominium Act. For HOAs, it's Chapter 720, which is the Homeowners Association Act. 90% of the things probably that are going to affect your community, if there's a statutory provision, are going to be in that respective statute, depending on which type of community that you're in. One thing I should probably mention too, especially I'm a Midwestern guy. I came from Wisconsin. When I moved down to Florida, up in Wisconsin, we didn't really have many condos. And I've heard of HOAs, but I just assumed that any type of community where there were covenants in place was an HOA. That's not actually the case. An HOA is actually a defined term that it's a homeowner association that's not a condo and it's not a cooperative, it's not a timeshare, but it could be a single family residence community. It could be a townhome community. It could be a master association that's made up of multiple types of residential associations, maybe a condo, a townhome, single family homes, but that's a homeowners association under 720. If you're a condo association, it's actually your own separate statute. So that's one thing that's important to note. The other thing is that as corporations not for profit, there's a statute governing those. That's Chapter 617 of the Florida statutes. We do have to look at that from time to time. So those are kind of the main governing laws. There are also other laws that are kind of sprinkled. I want to say sprinkled, but throughout different portions, of the governing statutes. There's one statute regarding energy efficient devices, for example, and it references, covenants and restrictions may not prohibit energy efficient or renewable energy sources, for example. So like that might be for clotheslines for an HOA. There's another statute that's actually from a federal standpoint about not being able to prohibit satellite dishes. So there's then there's a towing statute, and it talks about if you're a condo association, what you have to go through for a towing statute. So there's other different statutes. That's why it's so important to have, community association counsel that's aware of not only your governing documents, but also understands other laws that are out there that may affect your community that might not be in either the Condo Act or the HOA Act, for example. You're also trustees on behalf of others, just finishing out with this slide, and then you provide oversight and guidance to the association. So some of the qualities of good board members, again, you're going to find in some of this stuff, I hope you'll bear with me, that it's not all just technical. Here's the statute. Here's what it applies. I try to provide some practical advice. Doing this for 12 years and having attended a lot of board meetings and annual meetings, and I know our managers on here could probably tell stories that it's not just what your documents provide, it's dealing with people and personalities. So what we kind of find is, the qualities of a good board member are they have good character, strong integrity, calm judgment, a willingness to serve, committed to the best interests of the community as a whole, have relevant experience or background, previous volunteer service, have strong people skills, and is a servant leader. What is a servant leader? This was a term initially coined by Robert Greenleaf, who worked for AT&T. You need to be humble. You don't have a personal agenda, thoughtful in your approach, is respectful, willing to give time, and does what's in the best interest of the entire community. So some characteristics of servant leadership: listening, empathy, healing, awareness of people, persuasion, conceptualization, having foresight, stewardship, a commitment to growth, and building community. So again, kind of maybe a lot to think about, but I think that you'll find that the good board members that you work with kind of have some of these characteristics on the left-hand side. Some of the weak board members might have this. Now, I'll say this too, that maybe even if you fall within one of these categories, doesn't mean you're a bad board member, but it's a common characteristic when you combine all these for a bad board member. Unable to put the welfare of the community first, works behind the board to run things his or her way, is impulsive or quick-tempered, has a personal or hidden agenda, puts individual interests first, has little or no experience in management, leadership, or service, and is unable to work with others for the common good. So you can kind of see there. I have here too, you have kind of three types of board members. You might have the loss of power syndrome. Maybe they have deep leadership skills and they had power previously, but might be ego driven. They want to be relevant again and might not be interested in what others think. Or that never had power syndrome, which means that they have no experience, doesn't know what to do, has a personal agenda. Maybe they came on the board to kind of feel that type of power. So those are kind of maybe the not so great type of board members. Everybody on this call, on this webinar here, I know is a servant leader. That's the third type, which was what we talked about. And that's one that works on the best interests of the community on behalf of the members. So going into some of the officers and some of the roles and responsibilities, the president calls the meetings to order, announces the agenda and adheres to it, recognizes members entitled to the floor, states a question, calls a vote, and announces the outcomes, maintains order through impartial parliamentary procedure, expedites business, familiar with all the rules and documents of the association, and then appoints committees per the bylaws. The biggest thing probably for presidents that I like to remind them is, during the meetings, your manager will help you with this, but a lot of times it falls on the president to kind of chair the meeting and make sure that the meeting's going on in accordance with the agenda and making sure that things keep moving. If there's something that requires a vote, make sure that you have a motion made, that it's seconded, that there's appropriate discussion, and then calling it to vote. The biggest thing where meetings can get off the rails is when there's a discussion for a long time on an agenda item, and then there's, well, yeah, I think we should do this and this and this. Well, okay, we need to have a motion made on this, and then we'll move on to the next topic, right? So keeping the meetings moving. The other thing on here is really the president's the day-to-day officer. And what I like to say is if the board establishes a policy and establishes a budget and says, these are the things that we're responsible for, the president might be the one that makes the call on a day-to-day action. Like if there's a one-time $500 maintenance expense, really shouldn't be something that the board necessarily needs to vote on. That's something that needs to probably be responded to more quickly. And you need to be able to trust your president, your day-to-day officer, to make that decision, maybe working with your manager. So think of the president as the day-to-day officer that can help kind of guide things that doesn't require a board vote. There isn't a black and white, distinction between what can the president do versus what the board can do. And it's a thing that comes up with me a lot when I work with communities, and I'll have presidents say, hey, Ed, can I do this, or do I need to have a board vote? There's not always a clear answer. What I give generally is that if you're going to be obligating the association contractually, especially for an ongoing commitment, if it's a month to month, or a yearly contract for a service or something like that, you usually want to have the board review that and vote on it. If it's a one-time issue or an emergency or something like that, you want to be able to trust your president. And one thing that you might want to do from an operations standpoint is say, hey, we're going to allow the president to make a one-time call on any expense up to a certain dollar amount. That provides the very clear authority. So the president's not worried about having to call a board meeting and getting everybody on the same page, that they know what they have the trust and the authority to do something. Yeah, Lee, did you want to jump in?
Yes. Did you see me pop in there?
Yeah. Yep.
I like to do this from the back of the room when we have these meetings in person, but
Yep.
I just wanted to talk to this a little bit. First of all, I think legislatively next year, we're going to see some very interesting potential legislation come forward with regard to emergency powers for boards and what they may be able to do just because of what's happening through the COVID situation. But I had a situation recently come up with a client and had a board president get kind of icky with me because he unilaterally made a decision to cancel a contract. And I pushed back and I said, you need to do that at a properly noticed board meeting. That's not something that you as the president can come in and do on your own. So, on the one hand, as management companies, we love dealing with potentially one board member instead of taking direction from 5, 6, or 11 people sometimes. But there's a certain boundary that everybody has to follow, and contracts and things of that nature need to be handled by the board, not by one board member.
Yeah, that's great. And the big thing just to know with the president is that, like what Lee said, is if they cancel something, I get questions who say, Ed, we had this, or the president entered into this contract. Can we get out of it because the president didn't have board authority to do it? And my response is, you might have a claim against the president individually if they breach their fiduciary duty, but the vendor that has signed up there's a line of cases on this, but what's called a parent authority, that they can rely upon the president of a corporation to engage with them. And so you might not be able to get out of the contract, but you might have a cause of action against the president. Nobody wants to sue their neighbor, but that is one of the things why it's so important to make sure that the president knows how far they can go and that you trust that person that you're electing to be president, because they can make decisions that bind the association contractually with other parties. You just want to make sure that you have a clear understanding as to what they can do and what needs a board vote on it. All right, so the vice president, basically the same thing as the president in their absence. The secretary, I did get a question about this earlier, and it was a great question. The secretary and the treasurer are the two officer positions that when you have a management company, especially a management company, a great one like Vesta, where they do most of the things that the secretary and the treasurer are going to do, which is they'll maintain the records, they'll keep minutes of the meetings. Now they may have the secretary actually sign off on certain documents that they may prepare, but the secretary is not keeping all the records at their house. If you've got a management company, the management company is going to be maintaining those official records for you. That's what you contract with them for. The treasurer keeps thorough and accurate financial records, produces regular reports of disbursement and income. Again, all things that pretty much your management company are going to do, but produces an annual financial report to the membership, submits financial records for audits, and then authorizes the disbursement of funds. We talked about this before, but the scope of duties for the manager are specified by contractual agreement. You want to make sure, obviously, when you're engaging with a management company, that you look through what are their duties, what are their responsibilities there, carries out the policies as set forth by the board, administers the services, programs, and operations of the association, provides information, training, and leadership. So especially something like this, like Vesta does a great job at, which is coordinating education events, providing legal updates. That's what a very good manager does. Acts in the best interest of the association, and then keeps the board informed on progress of key projects. Some of the meetings, you have your annual meeting. That's where your budget may be presented, depending on the time of year. If your annual meeting's in the spring, you might not necessarily have that. Your election is going to take place at your annual meeting, and then you have a review of the previous year. For your board meetings, your frequency is going to be defined in your governing documents. You might have a certain requirement that you have to meet at least quarterly, for example. In some association documents, it says that. But you can always call special meetings as long as you have the president calling it or a majority of the board members doing it. Then you have membership meetings. One thing that's important to note is that the annual meeting is a membership meeting. So in other words, you need to have a quorum of the membership to be able to have that meeting, and that members, it's kind of their time a little bit more. If they need to adjourn the meeting to a later date, that's done by a member vote rather than a board vote. I've had that issue come up a lot recently. But it's also not, whenever you have a member meeting, when you make a quorum, it's not the time for the members to kind of, I kind of use the example of like Cinderella. It's not like her magical night to go to the ball and do something that they're not otherwise able to do for the rest of the year. Members are only able to vote on things that are authorized in the governing documents. So in other words, I attended a meeting where the members tried to make a motion to rescind a resolution of the board, or they tried to cancel a contract that the board had entered into. That's not something that's authorized on the membership in the governing documents. So I had to let them know, and the members didn't like hearing this, is that you're only able to vote as a member on certain things that are authorized. You can't go in and kind of undo certain things as the board. All you can do is have an election, and if you want to run for the board, then you get on the board and then make a change from a board level. So that's one thing that's important to note. But other membership meetings might be where you have a special vote to amend your documents, or to waive or reduce reserves, or authorize a lawsuit. It just depends, but you can have a separate membership meeting separate from your annual meeting. And then committee meetings for condos. We'll talk about the notice requirements, but for board meetings, for condos and for HOAs, you have to provide at least 48 hours notice unless there's a different requirement in your governing documents. And that has to be open to the membership, and you have to post it on the property in a conspicuous place. For condo committees, any committee for a condo association has to follow the same notice requirements and the openness requirements that a board meeting has. For HOAs, statutorily, that only applies to committees that have the ability to spend association funds. And then the architectural committee, I actually did get an interesting debate yesterday about this as to whether or not I would say that if you're making decisions as to parcel use, that especially needs to be open to the membership. I had an architectural committee, ask me, well, what if we're meeting solely to just discuss revising the architectural guidelines? Do we still have to have that as an open meeting? And I said, technically you might not be required to, but I would just recommend being conservative and having it open to the membership. The last thing you'd want is to maybe revise your architectural standards in a meeting that wasn't open to the membership, then try to enforce those standards later and have a court say that those guidelines are improper and that they're invalid because they weren't approved at an open architectural review committee meeting. So better to be safe than sorry, and that would be my recommendation. Now for HOAs, you might have a different requirement. You still need to look at your governing documents, but that's what's required by statute. So meeting requirements for quorum, you need to have a quorum for official business. Any interaction contributing to the development of ideas constitutes a meeting. This second bullet point under quorum, I call that kind of the barbecue rule. If you have a 5-member board of directors and 3 of you are at a community event or a barbecue or a social event, if you're talking about association business, that's technically a quorum, which means that you should notice that as a board meeting. Now, I know that that's coming from an attorney that we sit here in our ivory towers and start pronouncing things and we're not actually in the community ourselves. And I get that. And so from a practical level, the biggest thing that I would say is try to avoid as much as possible talking through things that should be on the agenda where you're discussing it at an open meeting. It's impractical to say that you're never going to talk with a majority of the board members outside of a meeting on something that might come up. The biggest reason why you want to try to avoid that is you don't want to have a situation where you talk through something as a board outside of a meeting, so that by the time you get to the meeting that you kind of rubber stamp something without ever having had discussion on it. And if a homeowner says, well, how did you know to make that decision? And the board says, well, we kind of already talked this through. That discussion should be done in an open board meeting. So I'm not saying you can't talk outside of a board meeting. And one way to kind of, I don't want to say get around this, but is if you have a 5-member board and you have an issue, have 2 members talk at one time. Or if you want to talk with the attorney and not have to notice it as a meeting with the attorney, have 2 of the 5 board members meet with the attorney, because then a quorum isn't met. So just think about something like that. But that is where that rule comes into place. And we do get questions about that. Talk about how the frequency for meetings is defined in the governing documents. You need to have proper notice. There are certain instances where you have to provide more than 48 hours notice for a board meeting. That could be for a budget meeting for a condo where you have to mail a copy of the proposed budget at least 14 days in advance. For HOAs, you don't have that same necessarily requirement in the statute for the budget, but both condos and HOAs, you have to have 14 days notice if you're going to pass a special assessment or if you're going to be passing a rule regarding unit or parcel use. So you do need to be mindful of some meetings might require more additional notice than what other meetings may. The last point here is something that you can say to kind of sound smart, especially when you have a homeowner that tries yelling at you saying you're not operating in the sunshine. You technically aren't, you're not subject to the Florida government and the sunshine laws because you're not a government or administrative agency. Now, that being said, condos and HOAs, the meeting and the openness requirements are very similar to what the government and the sunshine law is, but it doesn't actually apply to community associations. Some of the quorum requirements for condos for member meetings, it's typically a majority of the voting interests. For board meetings, it's a simple majority of the board. Quorum is not required for an election for a condo association if at least 20% of the eligible voters cast a ballot. So even if you don't have a majority of the members submit a proxy or show up in person, as long as 20% of them mail in your ballot, you can at least have your election at the annual meeting. And then suspended voting rights don't count towards anything towards whatever the quorum requirements are for a member meeting. So if you have a 100-member community, and this is for condos and for HOAs, if you have a 100-member community and 10 of those owners have had their voting rights suspended because they're 90 days or more delinquent, and you've provided them with appropriate notice, for the purposes of determining quorum or the voting interest, you've actually brought it down from 100 down to 90. So as long as you go through the appropriate process, it might make it easier for you to make quorum or to pass an amendment, that sort of thing. And I see I'm getting some questions here. We're going to be, I think, at a stopping point in a little bit for operation. So if you could just bear with me, I'll make sure to get to we've got about 15 or 17 questions here, and I'll make sure to get to those in a little bit. Quorum requirements for HOAs. This is actually a big difference, as that statutorily for HOAs, the maximum quorum requirement is 30% of the voting interest unless a lower amount is provided for in the bylaws. That makes it easier for HOAs than condos necessarily to have meetings of the membership, and you can amend your bylaws. And I've recommended for some large, like master associations I've worked with, to amend them to bring it even down, maybe down from 30% down to 15 or 10%. And the main reason is because you want to be able to conduct business. And I think there's justification for it, that you want to have, of course, a certain amount of people there to be able to conduct the meeting. But if those people care enough to show up, they should be able to make decisions then on behalf of the community, rather than people that don't care enough to ever send in a proxy or anything like that. Let's see, same thing about suspended voting rights not counting. Board meeting attendance, it's open to all owners. Anytime a quorum is present, the owners have the right to attend, unless these are the two ways that you can have a closed board meeting. One is if legal counsel is present for the purpose of providing legal advice. And this is the kicker though, it's regarding pending or possible litigation. So if you invite your attorney to attend and say, hey, we want our attorney and we want to talk to them about maybe changing some of our provisions in our declaration, that's not really regarding pending or possible litigation. So any discussion with that attorney would be at an open board meeting. You still have to provide meeting notification, even if it is in closed session. So what we normally recommend is either if you're putting it as an agenda item on an open board meeting, you might say that it's going to go into closed session and you kick the rest of the members out, or you call a special meeting where you say, we're having a meeting with our attorney, it's for proposed or pending litigation, but it's going to be closed to the membership. You still have to post that. So that is one requirement. The other thing is for personnel matters, if those are being addressed, closed board meetings are permitted. Just be careful about what you consider to be a personnel meeting. I've seen associations that have tried to kind of expand that a little bit too much. If there's a question about it, I talk with your manager and talk with your attorney. The last thing you want is to make a decision at a personnel meeting and then have that invalidated because it wasn't open to the membership. Board meetings for condos and for HOAs, actually, you can participate via video conferencing, so that if you're a board member, you can't be there personally. You can call in, telephone, FaceTime, Skype, whatever it is, as long as you're there in real time, you can be there and be counted for the purposes of obtaining a quorum. Email. So this kind of goes with the discussion outside of the meeting thing. Both the Condo Act and the HOA Act have been amended to state that board members are able to use email as a means of communication, but you cannot cast a vote on an association matter via email. So what I always say is just be careful. I think it's okay to discuss business via email, but don't discuss it so much that you're kind of exhausting your discussion so that by the time you get to the meeting, there's no further discussion and you kind of, rifle through all of your decision making. I think that, again, it deprives the owners of the ability to kind of see the discussion back and forth between the board members. Just know too that board emails, while if it's just between the board members, they might not be official records. There's still some debate about that. If you copy your manager on, they are considered official records. But if there's ever litigation, those emails are going to be discoverable. So of course, be careful about what you put in your emails. But the biggest question I have is say, well, Ed, it's just impractical. We do a lot of things via email and we want to vote. My response is one, call a 48-hour board meeting, have it by a telephone conference or something like that. But the other thing too is that when boards mention that to me, I usually find out that they're voting on things that don't really need to be voted on by a board. It's actually something that can be carried out by the management company or by the president of the association. So kind of take a look at it and say, well, we're doing so much by email. My response would be, I don't think you need to vote via email. I think that your president can make that decision. If the president wants to email them and say, hey, by the way, I'm going to be carrying out this activity. If you disagree with me on it, let me know. And then we can consider putting it on the agenda for a board meeting. That's one way that I would consider looking at it and kind of saving, any type of question about, well, this is going to make it impractical for us. My response, I kind of turn around again and say, you're voting too much on things that as a board that don't need to be voted on by the board. So just kind of look at that in your day-to-day operations. All right. So owner participation and personality problems. Owners are able to speak on a designated agenda item. You might want to adopt reasonable rules, especially if you have owners that are becoming problems. Reasonable rules might state that, you need to sign up at the beginning, and that you're able to speak for 3 minutes on an agenda item, and that it's either at the beginning of the meeting or at the end of the meeting or on whatever the designated item is. And you want to also include the time limit. Everybody has heard of kind of the 3-minute rule. That's deemed to be a reasonable period of time, but you really should have that as part of a rule and regulation that's been adopted. My recommendation always is get those in place up front so that you're not seen to be trying to make them up as you go during the board meeting. And somebody could challenge that and say, well, that's not a valid rule if you haven't adopted it and the board hasn't voted on it and it's not an agenda item. do that in advance so you've got it in place, part of your official records. So you'd say, hey, this is how we're going to handle our owners participating at meetings, and that way you've got it. Emergency action items may be considered. Meetings may be recorded. You can adopt reasonable rules regarding that. That can be, again, you might say if you're going to be recording the meeting, whether via recording device or via, if you're going to be video recording it, that you need to let us know in advance. If you're going to be doing it, it needs to be done in front of everybody else so they can see it. You can't move around, that kind of stuff. So be mindful that you can actually pass rules and regulations regarding that. The biggest thing, practical advice, is that limiting your board responses. Don't feel like just because somebody asks you a question or throws something out at you that you have to answer on the spot. You'd rather say, hey, thank you for bringing that up. We'll look into it. And if we need to, we'll bring it up at the next board meeting. You're not required as board members to answer every question that's posed to you by the membership. Planning board meetings, you want to define your purpose, create an agenda, date, time, and location, reviewing your minutes. You're going to have a pretty standard formula for how you're going to be having your board meetings. Invite the appropriate people. If you've got something that you need to, really run by the professional and it's better to have them in person. I know a lot of people that work with your community are happy to come to meetings, especially when they're not being yelled at, because I think they like to kind of show their face and let people know in the community that kind of put a face to it. When people tend to complain about, vendors or service providers, I know that they don't mind attending meetings and developing a further relationship. So think about inviting the appropriate people to the meetings. So some meeting hints: you want to start on time, stick to the agenda. Robert's Rules of Order, that's, you might be required. You might want to look at that. Florida statute doesn't require that you operate pursuant to it. And Robert's Rules are really meant for larger, what I would say larger boards or communities. There is a lot more leniency for smaller boards, which pretty much all of you are. But just the biggest thing to note is that you have some type of a consistent parliamentary procedure for keeping the meetings going, and recognizing people entitled to the floor, a motion being made, having it seconded, that there be debate, and then a vote on it. Those are the big things for running your meetings. Meeting minutes, it's an important document maintained by the association. It serves as the official record of the organization, and it serves as the basis for action taken by the board. As of right now, for condos, meeting minutes have to be maintained in perpetuity. So while people, you're going to forget what's going to be said, on a back and forth word for word basis, but your minutes are going to be there forever. Now for condos, it's 7 years for HOAs, but there's a push to have that amended to have the HOA statute catch up to the condo, where minutes are going to be maintained in perpetuity. Yeah, Lee, go ahead.
Thank you. One of the things that we often talk to our board members about, we have some folks that really think that we're supposed to be doing like transcripts. And we try to remind board members that, minutes are official records, and basically, here's the content right there. There's your screen. It's not meant to be like a court reporter transcript of what everybody said about everything. It's really action taken. And we struggle with that. Sometimes people want them to be longer and fuller. So any input you have on that would be greatly appreciated.
Yeah, that's the biggest thing that I always say, is that the minutes are not meant to be a transcript. If somebody wants that, that's why they have the ability to tape record the meeting, so that they know exactly what was said, and if they want to try to use that later. But it's not a requirement of the board to do that. And frankly, I try to get the boards to, if possible, keep their minutes to one page, depending on how many agendas. If you've got a big meeting where a lot of business is being conducted, might not be able to keep it on one page. But for example, if you take your agenda, I always say you take your agenda, cut and paste it, and that's the basis for your minutes. And then you're basically plugging in the action taken for each agenda item. The action for each agenda item, it's not this person said this person rebutted by saying X, Y, and Z, and all of a sudden now you've got multiple paragraphs for each agenda item. That's not what's intended, and I would highly advise against it, just as association counsel, because what if there's something that was brought up casually that nobody knew about, but was actually the basis of a future legal issue, where they can come back and say, oh, hey, it looks like in the minutes here that you all discussed this, but it took you this long to bring it back up. You've waived your ability to bring this claim up. It's better just to have it say what the action taken was, if there was a motion made, if an item was tabled, and that's about it. So that's the biggest thing, I think, following up on what Lee said. And so when homeowners say, I demand that it be reflected in the minutes that I brought this up and the board didn't do anything, you're not required to do that at all as a board. Same thing for board members. If they reflect, I demand that it be reflected in the minutes that I voted against, I not only did I vote against this, but these are the reasons for doing it. You're not required to do that as the secretary in terms of how the minutes are being kept. All right, so our next topic is going to be elections, but I'm going to check through and see where we're at with some questions here and try to answer some of these and maybe hold some of these just so we can get through the rest, and we'll answer the rest of the questions at the end. One question was, in condominiums, do rules and regulations have to be recorded with the state? That's a good question. Let me see. I'm actually going to pull this up because I know that the HOA statute was amended where they included rules and regulations as a governing document, and that it said that changes to the governing documents have to be recorded with the state. I'm not aware that that is actually a requirement for the condominiums. I'll take a look at that and come back to it. But I know for rules and regulations, when you're amending those now, you actually do have to record those amended rules and regulations. I've even gone so far as to say that if you're amending your architectural standards, because I consider those to be, akin to a rule and regulation, although they're not the exact, same thing in title, that it's safer to record those as well. So that's one thing. It hasn't been tested yet, though. Tanya asked, where are the bylaws filed? Those do not have to be filed with the state, although any amendments to the bylaws do have to be recorded in the Condo Act and in the HOA Act because they're a governing document. So it just depends. But it depends on how old your community is of whether or not they need to be recorded in the first place, but any changes to those do need to be recorded in the public records. Let's see. One question from Harry is, how can insurance companies hold inquiries to see if you have a claim as a claim and threaten to drop you? I don't know if I fully understand the question there. They're not allowed to retaliate against you for filing a claim, if that makes sense. If you do have an issue where you fail to file a claim, or if you file one and you have an insurance proceeds available and you don't use that to fix the issue, you might have an issue with coverage or on a future claim. So I don't know if that fully addresses your question, Harry. If you want to maybe clarify that and type that out, I'd be happy to try to get to that later. How does a conflict of interest apply to board members? The biggest thing is if there's a financial interest for that board member. If a board member feels one thing about, I don't like this because I live next to them, that might be different and maybe part of their decision making, and it's not as clear as to, that it's clearly a conflict of interest issue. The biggest thing for conflict is, a board member has an ownership interest in a vendor and doesn't disclose that, and then they vote in favor of that vendor having a contract with the community. That, of course, is a conflict of interest there. Good question from Marilyn about do you have to have elections if no one new is running? I'm going to hold that, but I'll just answer that right now because we're going to get into that in a little bit. For condos, if you don't have more candidates than there are vacancies, then you don't have to have an election. Whoever gets their name in on time is seated on the board. For HOAs, it's a little bit different because you have to have a process for nominating in advance in your bylaws to then be able to say, okay, we had a way for people to get their name in. We don't have enough people, or we don't have enough to have an election. Therefore, we're going to automatically seat those that got their name in on time. It is document specific for HOAs, though. Jerry said, should the president be the only board member to interface with the management company? That's a great question. I think it just depends upon your relationship with the manager. I think sometimes that the treasurer will interact with the manager too on financial issues, but I know for the most part, and I know Lee said this before, that they like interacting with one board member, and usually it's the president, just to make sure that they're not receiving conflicting directions. So that's typically what I would recommend and what management companies recommend. Paul asked if a copy of the slides are going to be emailed to the participants. Yes, and what we can do is, and actually what I think I might just do, instead of you having to request that from me, when we email out the certificate, I'm just going to have Nanny from my office, when she emails out the certificate, we'll also email everybody a copy of the PowerPoint. That'll be easier than you having to request that from me. Patrick says, my condo is part of several condos in our very close area, and we belong to what is called a property owners association. What Florida statutes govern this larger one? It's a great question. The property owners association, if it's made up of condos and also, single family detached homes or townhomes, then that property owners association is going to be governed under Chapter 720 of the Florida statutes. However, there's some case law that says that if it's a bunch of different condos and then there's one overriding master association, but that you can only have condos in there and there can never be anything else, then that master association will also be subject to the Condominium Act. There's some case law on that. So it depends on, aside from your condo, what other type of home ownership there is that's within that master association, that property owners association. Jerry says, once reserves are established, may they be amended at the budget meeting without a member vote? That's a great question. We're going to get to that a little bit later. I'm going to keep this answer up. One question is, how should a new board member or president address local neighbors who approach with questions or concerns, especially if it involves HOA dues or increases? So I think the question is, if you have homeowners, if you're new on the board and somebody starts, bringing stuff up to you and they want to ask you stuff outside the meeting, what I would recommend, just for your own sanity a little bit, is to say, hey, can you do me a favor? Can you email this question or this comment over to our manager? Then what happens is that manager emails it out to the board. We'll review it. And if we need to, we'll bring it up at our next membership meeting. That way you're not being caught off guard outside and feeling like you're having to answer questions outside of a meeting and being held to something. And it's a nice orderly way of making sure that everything goes through, there's a process for it, and that it creates expectations for the owners there. Steve asked, what covenants require board approval? And I think the question is what that requires a board resolution versus maybe membership approval. So for the most part, any changes to your declaration of condominium, your covenants or your covenants and restrictions are require membership approval. Your articles usually require membership approval. Your bylaws, though, and your rules usually can be done by board vote, especially your rules and regulations. Oh, okay. I'm sorry. And I misread this too. It says, when covenants require a board approval, does that mandate a board resolution, or can any director sign or approve the application? If it does say board approval, I would put it on the agenda for a board meeting, unless the board maybe establishes a resolution delegating that decision-making authority to one of the officers. So I apologize, Steve, I misread your question there. There's a question that says, our board discusses issues via email and makes a decision on the topic. Are we saying that's improper without notice of a meeting? Yes, just because if you're voting on something that requires a board vote, if it's done via email, the statute prohibits that. So we want to make sure that you're putting that on the agenda for a board meeting or determining whether or not that actually requires board approval in the first place. There was a follow-up question about the board having a meeting with the attorney discussing legal matters, that could take place without notification. That's actually, it's not correct. You still have to notice the members, but if it is for a properly closed board meeting, you can say that it's going to be a closed meeting. But if you're meeting with the attorney, if you have a quorum of the board present, that is considered to be a meeting, and we have to notice that to the membership. Yeah, go ahead, Lee.
Just a question on that. When we have these closed meetings, and it does happen, should there be minutes kept of those meetings, even though those minutes wouldn't be distributed?
That's a good question. I like having closed, as long as the biggest thing, as long as the records are being very carefully kept, that you almost have, and we're going to talk about records inspection later, right? But you have, these are all the records that we have to be made available. These are the records that aren't open for inspection. As long as they're carefully maintaining that, so that the board can kind of reflect back as to any decision that was made at a closed meeting, that you can keep those minutes separately. I know there's some debate on that, but a lot of times though, that you might not need to keep it if there's a discussion, but that it does require, I know I've been involved where there's a closed discussion, but that the board still needs to vote on an item. I might say, let's close this, let's get out of the closed meeting, and then you can make a motion to approve like a settlement recommendation or something like that. You're not going to discuss what that recommendation is or anything else, but that at least you can reflect that the decision was made in an open minutes. There's still some debate on that. I think even if you did that in closed meeting and you have the minutes to reflect that it was done, just make sure that those minutes are kept separate, right? That's the biggest thing. Yeah.
Two concerns. God forbid somebody inadvertently released those, thinking that's an okay thing to do. And then the second one is, I've actually had a situation recently, which had never happened to me before in all the years I've been doing this, where we had board members post the meeting and decisions being made, taking a position against what the board had actually approved to do.
So
So all of a sudden we didn't have minutes, and we had a couple of board members that said, I never approved that. It was
yeah,
weird.
that comes down, it sounds like a duty, like the duty of loyalty and confidentiality issue, and you need to act as one unit and
Yeah,
understand
okay.
that you can vote against something, but you got to go along with what the minutes say. That when you start having that, that's when there's problems with the board, right? When they start posting stuff.
Yeah,
And
different
then,
subject.
yeah,
Okay.
and what was your first, I'm sorry, what was your first question?
Well,
Leah?
in my experience, we've never recorded minutes for closed meetings. We kind of are dependent upon the attorney to be the person that says, this is what the board decided. Just this recent situation where we had the board make a decision, and then after the fact, we had board members that were saying, well, I never agreed to do that, when in fact they did, and I didn't have minutes. So I just had never had that situation come up.
That's where they would be important in case there's some type of claim by that board member against the rest of, or something that you can say, no, you were part of this, and here's where the minutes were taken that we kept separate. But I think the biggest thing, again, is just making sure that, because that's a confidential document that we don't want to make available, that we keep it separate. But yeah.
Right.
Yeah.
Okay.
Yeah.
Okay. Thanks.
I'll try to take a couple more questions, then we'll jump on, because I know we're running over here. I want to get through the rest of the slides. Greg says your bylaws are not very clear. You have a question regarding it. I'll try to maybe address that later if you want to type a more specific question. Who owns the windows in a condominium, the owner of the building? That's going to be very document specific from a maintenance standpoint and from an insurable standpoint. So not to kind of duck that, but that is a very document specific question for your condominium as to maintenance responsibility and whether it's deemed to be included as part of the unit or the common elements. Then a question was regarding railings on the balconies. Who's responsible for the repairs? Also very dependent. It might be that the owners have to keep the balconies in a neat and clean condition, but anything that's more structural or substantive in nature, that it's usually going to be a board responsibility through the association. But it does depend on what your documents provide. Kathy says, what if the bylaws are not dated or signed? That would be an interesting thing. We'd have to look at whether or not, if it's still recorded or is attached as an exhibit to the declaration, I think you can treat them as being valid. Even, usually the articles may say that the board can establish bylaws. If there's a question on it, you can just always ratify those as a board, but it might depend upon what your governing documents may require. Let's see, there's a question here about records being maintained via hard copy. We'll talk about that a little bit. Should some committees share reports with members? I think that any committee reports become official records. And so we'll talk about official records a little bit, that they may be open for inspection by the membership. I'm of the opinion, if you're there and you're reviewing it, and if it's going to be an official record, I think it helps with the transparency. I think it just depends on your community. And if there's some distrust that by providing those reports that you're relying upon for decision making, that may kind of diffuse any type of situation, feeling like, well, we don't know how you're making decisions and you're making us jump through hoops to get copies of these things. I think it just depends on your community there. Al says, is there the notice requirement for rule changes 48 hours or 14 days? So if it's a rule change regarding a unit and what you can do with your condominium unit or with your individual parcel, that requires 14 days notice. If it's a rule change regarding the common areas, that doesn't require the 14-day notice. It can just be a 48-hour notice. So Patrick said for the larger POA question, let's see, you had condos, restaurants. So it sounds like condo, commercial, that for that POA, there's a more nuanced answer there, Patrick, but it comes down to the HOA statute only applies to a residential portion of the community. So in that circumstance, you're probably not going to have 720 apply. It's going to be chapter 617 as a corporation, not for profit. And so you're going to be really dependent upon what the covenants say for that type of large POA. One question was, do committee meetings need to be open and posted for an HOA? I think I answered that regarding if it's a committee that can disperse funds or if they're making architectural decisions. And I would say that just to be safe, any type of architectural committee meeting should be noticed and open to the membership. And then the last question I'll take here before we jump on to elections: can the board discuss an issue via email before the meeting? Yes, that's okay, but I just be careful about how much you discuss it so that you're not kind of fleshing out an issue so that by the time you get there, you're kind of just rifling through everything, because the members are going to be upset. And that might be more of a practical issue. There's no case law on this that says, that an action is invalidated, even though they voted on it at an open board meeting, that they discussed it so much. There's no case law on that. What it is, it's more of a practical thing that owners feel like the board is doing things in the dark outside of the view of the membership. And that's when there's distrust. And then you have more contentious issues with the board. So try to avoid having too much discussion via email so that you can have it at the actual board meeting. All right, so we're going to jump into elections here. I'll try to run through it quickly. So for condos, I'm going to really summarize a lot of this. The big thing for condos is that it's very statutorily driven. You have 2 notice requirements. It's going to be held at the annual meeting. You have a 60-day notice for your first notice of the annual meeting for the election. That first notice says, we're having the annual meeting on this date. If you'd like to run for the board, you need to get your name in by this date. You have to get your candidate information sheet by this date. That's the main thing to kind of summarize what this slide says. Your bylaws may provide for term limits. And what that could be a couple things. Term limits might be, how long do you serve on the board? Is it a 2-year term? Is it a 1-year term? Your bylaws provide for that. And also your bylaws may say that you cannot serve for more than 8 consecutive years or something. And there's a statute that talks about that in the next slide. So it is going to be bylaw dependent on, the length of term. And if you have a kind of a maximum term limit before you have to sit off and then run for the board again. The updated in July of 18, there's still some debate about this as to whether or not, if you've served at least 8 consecutive years on your board, you can run again. But if the statute applies, and we're still waiting for further guidance on this, but you can run for the board and you can be elected if you obtain at least 2/3 of the votes cast at the election, or if there aren't more candidates and vacancies. So if you put your name in and there's 5 spots open and only 4 other people in addition to you, then even if you've been running and serving for more than 8 consecutive years, you can still serve on the board because there aren't more candidates than vacancies. This only applies to condos, by the way. It doesn't apply to HOAs. If you do have a question, if you are in a community and if you are a board member, I'm assuming most of you are new board members, but if you have any existing board members that have a question, they should just talk with their attorney about it the next time that it's coming up for the election, so that you can get an opinion from the attorney as to whether or not they should be able to run or how that should be held. We talked about the 60-day notice. You have to submit your name. I mentioned on a previous slide, it has to be 40 days in advance at least. Then you have another 5 days before you have to get in what's called the candidate information sheet. That's kind of a 1-page document that says why you're running for the board, what your qualifications are. And then after that, you have to send out the second notice, at least 14 days, but not more than 34 days. That includes the agenda, and then it includes the ballots and says, these are the people that got their name in on time and that are eligible to run for the board. It's listed alphabetically. It's a nice orderly process that says there is going to be election. You need to vote for this many candidates, return the ballot back in the enclosed envelopes. There's a whole process for signing it. Everybody right now has been looking in the news for election procedures in terms of signing off on your envelope and what's required there and secrecy of ballots, but it's a very orderly process for condos. If you're in an HOA, I highly recommend, that this could all be applicable to you from the standpoint of, I've worked with a lot of associations that have had election issues, and I've told them, you should really consider amending your bylaws to provide for the condo form of election, just because it's hard to mess it up. It's very black and white. Whereas for HOAs, and we'll talk about it right now, HOAs are a little bit more like the Wild Wild West. It's very document specific. And if your documents are not very detailed as to how the election process should go, it can create cause of confusion. I'll give you an example. Maybe this rings true for some of you that you have communities like this, or your bylaws, I should say, where it might just say election, board members serve an annual, a 1-year term, and that they're elected at the annual meeting, which needs to be provided with at least 14 days notice. That's it. A lot of communities might take that and they'll send out a notice and they'll ask for candidates. And then they'll send out a mail out that says that these are the people running for the board, but you can also nominate yourself from the floor. I would argue that even asking for people to submit their name in advance and then sending a mail out with their name on a ballot is in violation of the bylaws, because how did the board establish that cutoff date to get your name in, to get your name on the mail out? If it's not provided in the bylaws, an arbitrator could toss that election, and there's cases on that. And so what you really want to make sure that you do is, if you're going to require a nomination in advance process, is to have it in your bylaws. The arbitration case that I'm referring to, I believe that association, they had a very similar process to the condo form for like 10 years at least. And a homeowner didn't get his name in on time to be on the mailed ballot. He challenged the election results. The condo or the HOA said, well, he didn't get his name in on time, and we've been doing this for 10 years and we let everybody know. The arbitrator said, it doesn't matter what your policy is, because you might have a new board that just decides they want to change it later. What matters is that it's in the bylaws. So whatever's in your bylaws is going to control. So I'd highly recommend that you take a look at your bylaws with your election procedures and make sure that you have it for nominating in advance. I know a lot of communities don't like allowing nominations from the floor. And in order to get away from requiring that, you have to have a process for nominating in advance in your bylaws. Yeah, Lee, go ahead.
Oh my gosh, you're just so preaching to the choir. And when you said like the wild, wild west, I couldn't help but laugh out loud, because
Yeah,
HOA elections make me crazy.
yeah,
And we're trying really hard, especially in light of the pandemic and what we've been going through this year, to utilize electronic voting opportunities,
yep,
which is terrific. And for our very large communities, which are typically HOAs, not COAs, it
right.
saves them thousands of dollars. I mean, just achieving a quorum is a challenge, but this nomination from the floor thing is just brain damaging.
Right.
So is there any thought process, and maybe you know this, Ed, for lobbying the legislature to ultimately get the HOA 720 Act to be a mirror of 718 when it comes to elections?
You know, I haven't seen it go so far as trying to copy the Condo Act from an election standpoint. We have seen some changes in the last 4 or 5 years. And actually in the next slide, there was a change in 18 where they keep kind of incrementally saying that if you have a process for nominating in advance, then if you don't have more candidates and vacancies, then you don't have to have a quorum. You know, so they've done
Right.
some of that. But in terms of going fully requirement by statute, I haven't seen that yet. But it's always something that we bring up. We're involved in, as you know, with whether it's CAI or other organizations that have
Right.
lobbyists, that is stuff that's brought up. I'm not sure that there's been a huge push though to go to that very specific. It's more document specific. And that's why I always try to preach it on the local for that association and it's usually a board vote to change it, right? To go to amend their bylaws. So I'd highly recommend looking at that as a board. And then, like you said, electronic voting, I just talked with a community last night, and I know that different vendors charge different things, but you might be talking about $800 to $1,200 to get it all set up and to have everything ready in place. But then once you have it, you can use it going forward. And for a large community, just to save on the mail out costs for all the people
Oh
that
my
opt in.
gosh.
Yeah.
Yeah. I mean, we
So,
have a client that has almost 6,000 homes, and I can tell you that their annual meeting mailing, just the initial mailing, was over $15,000.
wow.
And we were able to do electronic voting for the first time. And so we're talking, less than $5,000. It saved over $10,000 for this one
Right.
association. So to all my HOA clients out there, listen to the attorney. Let's talk about amending your documents and try to eliminate this nominations from the floor, because it really, it just makes everything a bit of a mess. So.
Absolutely. Yep. Going to eligibility, the main thing, and this is an issue that comes up too sometimes, even if your bylaws say that, well, if you haven't lived here for at least a year, or if you're in a homeowners association, if you're just a lot owner, but you haven't built your house yet, you're not eligible to run for the board. That's going to be overturned, and the statute's going to control, which says that everybody's eligible to run unless you are 90 days or more delinquent in a monetary obligation, or if you've been convicted of a felony and you haven't had your civil rights restored for 5 years. Those are the only 2 ways that you're not eligible to run for the board. So that's where the statute's going to control over what the governing documents may provide. And that's for condos and for HOAs. Talked about this. This is the update to the statute that says for HOAs that if you do have a process for nominating in advance in the documents, then you don't have to allow nominations from the floor, and that you commence service at the date of the annual meeting, regardless of whether quorum is met. That's a big thing, because if you don't have it, maybe you'd think that only 2 or 3 people are going to run for 3 spots, But if you don't have a nomination and advance process, and you have to allow nominations from the floor, if you don't make quorum at that meeting, then those candidates don't take office. It's the previous board members that serve as what are called holdover directors. So that's why it's so important to have the nomination and advance process, so that you're going to know if you need to make your quorum or if an election needs to be held or not. Board member recall. I'm not going to go too far into this and just say that the statute's been amended. There's a recall process for both condos and HOAs. That's the process for removing a director before their term is up, and it requires a majority approval of the membership, whether it's by a called meeting or by a written petition. Just know if you get one of these that you do have to act very quickly on it. I have one client that's going through it right now, and it's because you have 5 business days to certify the recall effort, and if it's deemed to be certified, then that new board takes over right away. So if you get one of those, just know that you really need to involve your attorney on it to review it to see if it's valid and to advise the board on what the next steps are. Proxy rules for condos. For limited proxies, you must vote as specified on the proxy. So a limited proxy is kind of like, I can't be there, and you might leave it blank to say, if I don't name anybody, then the secretary or the president's my default proxy holder. But for your vote to count, I actually have to vote yes or no on an issue. And most of the things that require a vote for condos have to be done by limited proxy. There's not much that you can do outside of using a limited proxy, unless it's like general powers might be adjourning a meeting to a later date or something like that. But for the most part, any substantive vote by condo that you can do by proxy is by limited proxy. That prevents the proxy holder from showing up with 50 proxies and saying, hey, I get to vote however I want on these issues. They're just kind of handing off the proxy and saying this is what their vote is and I'm here in their place, that kind of thing. Limited and general proxies may be used to establish a quorum, and the proxy is valid for 90 days from the date of the meeting. That's important because maybe you're not quite there to have the effective vote or to make a quorum. You can move to adjourn the meeting to a later date and go and obtain more proxies. The previous proxies are still valid, and you can accumulate more so that you can have your vote necessary. So that's why it's nice that the proxies are valid for 90 days. Proxy rules for HOAs. Directors may not vote by proxy at board meetings. That's the same thing for condos. Members have the right to vote by proxy, but there's not the same limited proxy voting requirement. It might depend on what your documents provide. You need to look at that. Proxy is valid for the meeting for which it's intended, and it's for 90 days if you adjourn it to a later date. All right, I'm just going to check and see if we have any election questions before I go to the financial side here. Kathy says, what if the condo docs for the election are written more like an HOA election? Can the condo association follow their docs? That's a good question. It's actually, you have to follow the condo statute on that. So that may be one of those where maybe poor drafting by the entity drafting those documents, but you do actually have to follow the Condo Act and the administrative code for how the election is going to take place. Allie says, does Chapter 718 require board members to be homeowners? If not, can that be stipulated in the governing documents? You do need to take a look at what your governing documents provide. I'm not aware that in the Condo Act that that you actually have to be a member. It's going to be document specific. Most of them will say that you do have to be a member for you to serve on your board, but it's not a requirement in the state statute. This question is, meetings during COVID allowed video, Zoom or Teams or whatever the case may be. Can a meeting be held via email? Okay, so voting on resolutions, quorum established by enough directors participating by email exchange. Okay, so I think to kind of unpack this with COVID, the biggest thing that I would say is that I've been more comfortable with boards having completely virtual meetings. And the reason is because board members have always had the ability to attend virtually and have their vote count. So I'm okay with having completely virtual board meetings as long as, of course, members are able to participate. There is the small chance that somebody could argue that the meeting wasn't valid because you're supposed to have a physical location. Even if none of the board members show up, that a member could show up, I suppose, and have a speakerphone there. I'm okay with that from a board standpoint. From a membership standpoint, there's been some debate about this, about whether or not you can have a completely virtual membership meeting. I've advised against it just because you might be depriving a member of the ability to show up in person to vote on something if they fail to send in their ballot or their proxy. And by doing that, that's my concern. There may be a mechanism under the non-for-profit corporation statute that allows you to count members present virtually without having to submit a proxy. It hasn't been tested yet, and I would want to fully research that and provide an opinion and have the board be aware of the risks. The main thing is just verifying that that's the actual owner. When you don't have them showing up or submitting a proxy, it's a different way that never has really been done before. And you'd want to have a well thought out way to consider them present. And then the question is, even if they're present, are they able to vote solely via Zoom? And whether or not you have to actually implement electronic voting, for example. So that's where I've said, have a physical location for the annual meeting where the election is going to take place, but encourage owners to get everything in advance, and that if they need to show up, it's only for the purpose of dropping off a proxy or a ballot, but that they are asked to go back to their home and participate via telephone conference, Zoom, whatever the case may be. And then you have kind of what I call a skeleton crew for the meeting itself, which is you might have some of the board members there, the manager, and maybe some volunteers to help count the ballots, and that be it. That's what I've been recommending. And then trying to have that, if you think that people are still going to show up, have it at an open location. At least now we're getting into the nicer weather months. We are in the nicer weather months, that you have it at an outdoor location. But I've avoided giving a strong recommendation on having a completely virtual member meeting. I've still been recommending, and what we've been doing as a firm is recommending having some type of physical location, but in all of the notices saying this should only be used if you forget to mail in advance. Otherwise, we encourage you to mail everything in advance and then participate via Zoom or Teams or whatever the case may be. Reginald asks, can renters participate in the HOA, i.e. hold office vote? That's a good question. Voting, no. They'd have to have some type of a power of attorney from the actual owner. Can they be elected? That kind of goes back to the question of, do you have to be an actual owner to be able to serve? That would be document specific. I just don't see that happen very often for renters at all. Jacqueline says, we're using online voting now at our condo. What is the law covering storing ballots? I think the question is, what do you do with the electronic voting results? All those results have to be maintained as an official record of the association, along with the actual paper ballot. So that was actually amended in the Condo Act. They actually didn't amend the HOA Act to say that you have to maintain the electronic voting results. I would still recommend doing that. There's a question that says, if there's an offsite rental management company telling owners who to vote for, is that a problem? Not necessarily. There's nothing really prohibiting that you can use to enforce. Now, certainly if they're making defamatory statements or untrue statements, the person against whom they're saying that could have a cause of action against them for defamation. But really, from a condo standpoint, there's not much that you can do there. All right, so we're going to go into talk about financial issues. We're going to talk about budgets, your operations, your reserves, and your accounting methods. Monitor your accounting records must be open to inspection. Accuracy, of course, is critical. Establishing assessments, whether it's regular or special assessments, and then what your financial reporting requirements are. All right, your budget, it allows your association to prepare for the upcoming year. The proposed budget includes the daily operational expenses and the estimated revenues. For condos, the owners are entitled to 14 days written notice of the budget meeting unless the bylaws or the governing documents provide for longer notice. Meeting notice is required to be accompanied by a copy of the proposed budget. For HOAs, this is a big difference. The association shall provide each member with a copy of the annual budget or written notice that a copy is available upon request. The only thing for the budget meeting is that the HOA has to, when it's posting the meeting notice, specifically state that assessments are going to be considered at that meeting. Now, your bylaws, your governing documents may require something different. Usually it's actually not that specific, but a lot of HOAs just kind of treat it like the Condo Act, where they're going to mail out a copy of it to them in advance, but it's not required like it is in the Condo Act. Your budgets are going to be zero-based. What that means is that you're going to establish what your expenses are and then how you're going to have your income to match those expenses so that at the end of the day that they match. Obviously, the association is not going to be deriving an income and not deriving an income for its members. It's meant to basically have the assessments offset what the expenses are. All right, so for your annual budget, your governing documents are going to set forth the responsibilities for preparing, implementing, and funding the annual budget. Most budgets contain your administrative costs, your maintenance, taxes, insurance, reserves, taxes, utilities. Your insurance premium is going to be one of your biggest line items, along with probably your management company, your landscaping fees, legal fees, that kind of thing. just remember too, the biggest thing with your budget is that it's not the specific requirement that you can only go up to that dollar amount. If you have something that's an issue, that's an association responsibility, and maybe you underfunded that for the year, I would highly advise against the board saying, well, it's October and we've got this issue and we got to fix some of this stuff, but we're over budget, so we're going to wait till next year for it. I'd advise against that, because what if you fail to fix something and then it gets worse, or somebody gets injured or something else like that, or somebody's harmed by it? They're going to come after the association, and you can't use that, well, we went over budget for the year. The budget's meant to be an estimate. It's not meant to be a limit as to what you're able to do. So that's the biggest thing that I can recommend when you're looking at your budgets there. Now, obviously, you don't want to go start shooting over it if it's not necessary. I'm talking about necessary items that come up and not feel like you're held to what the budget requirements are. Cash versus accrual basis. Accrual gives the overall financial picture, and GAAP requires the accrual basis method. That means that income is recorded when it's earned and expenses are recorded when they're incurred. Cash basis accounting, it's kind of similar to a checkbook where it records income when deposited and expenses are when paid. But the cash basis may not accurately reflect the association's true financial condition. It just shows the result of cash transactions. So outstanding assessments and unpaid expenses are missing, as opposed to accrual, where it records income when it's earned and expenses when they're incurred. Statements are more useful for comparing the results of the budget to the actual activity. They take into account the timing differences. So that's where most associations go in the accrual method. Financial reports, I have this on here just for your community. You have to provide an annual financial report, and it depends upon what your total annual revenues are. If it's less than 150,000, it's a report of cash receipts and expenditures. If your annual revenues are 150,000 but no more than 300,000, and it's a compiled statement. Compiled is it's no audit or review and there's no opinion expressed. The CPA must have the client and industry knowledge, and then looking for any obvious departures from the generally accepted accounting principles. A reviewed statement, that's a level above. That's for annual revenues of at least 300,000, but no more than 500,000. It expresses a limited opinion that the statements are in conformity with GAAP. Generally look at related party transactions, segregation of duties, cash and other key financial items, and then any significant financial fluctuations. And then you have your audited financial statements. That's the most expensive and the most thorough. And that's for any annual revenues of $500,000 or more. It expresses an opinion that the financial statements present fairly and the financial position are prepared in accordance with the generally accepted accounting principles. You want to look at the internal controls and perform analytical tests. So I kind of skip over that for the condo for the financial. If you fail, you need to make sure that you provide a copy of the financial report. There is a way for you to waive the financial reporting requirements, but it requires a majority of the members appearing at a meeting where a quorum is met. And you have to do that annually. You can't have that vote and say, we're going to waive our audit for the next 3 years. It has to be done annually. If you don't provide a copy of the financial report on a condo and then you're ordered to produce it and you still fail to, the division can say, hey, we're prohibiting your ability from waiving the financial reporting requirements for which you are, within that threshold. That's kind of the penalty for it. Doesn't happen all that often. So funding the budget, it's for assessments required from each owner. The unit or the property serves as security to ensure payment of the assessments. Other sources of revenue may come from rent, interest, or whatever the case may be. And then the payment schedule must be determined. Most payments are monthly, can't be less than quarterly for condos. For HOAs, you can have annual assessments or whatever the case may be, twice a year. The big thing too is when you're budgeting and you're trying, I know there's sometimes an effort to kind of keep assessments low by trying to maybe estimating other sources of revenue, whether it be by fines or, late fees or interest or stuff like that. I try to avoid that as much as possible, just because, especially, it's interesting. For one community I was working with, they were wanting to implement speeding fines because they own their private roads and they had problems with speeding. And there was a community up in Illinois that had a pretty well-developed process for speeding and enforcement. And I actually talked with the manager up there, and they said, yeah, we have this, and it's a great source of revenue for us. We have $40,000 a year budgeted for fines. I mean, you want to talk about like making sure, it's kind of like the stigma. If any of you have been through, I know they've made it better, but if you're around Gainesville, or I think it was Waldo, where, that was a notorious speed trap. And I think they got into trouble for basically having like a quota for speeding tickets. you don't want to have that stigma attached to your community. So I would avoid budgeting for fines as a source of revenue, because that's just a self-fulfilling prophecy there. I'd avoid doing that. For condos, if you ever hear that, well, we can't raise our dues this year because there's a statute that says you can't raise it more than 15%. The only thing that statute says is that if you do raise them more than 15%, then 10% of the voting interest can request a special meeting to consider a substitute budget, but it still requires majority approval of all the members to adopt the special budget. That's never happened in all the years that I've been practicing. I know I've spoken with Lee and her role as managing communities, that's never happened either. But it's a possibility. It's just, it doesn't mean that you can't go above it. It's just that it creates a possibility for it. You do need to look at your governing documents though. I do find it more in the HOA realm, where developers might say that the maximum monthly assessment is $40 and it can't be raised more than 5% each year. You can tell why they do it. They do it for the purposes of for marketing and to market that as part of the initial sales. They don't really care what happens once they're gone and they're out of the development. So you still might have governing document limitations as to raising the dues. Collections of assessments, the manner for collection is stated in the bylaws of governing documents, must be no less frequently than quarterly for condos. You can accelerate assessments for delinquency. You want to manage your delinquencies by establishing a collection policy. We talked about that earlier. I think it's extremely important to have something like that so that you give clear direction to your management team. So that, especially if you don't meet monthly, maybe you only meet quarterly, you don't want to have your management company say, hey, I don't have authority on this, so I had to wait until your next quarterly meeting before we took the next step on this. If you establish a resolution that says that if an account reaches a certain date, then management can send out this notice, and then once that expires, then they can send out this one, and once that expires, it goes to the attorney. That keeps your collections moving on a very clear and consistent basis, so that it's not being held up by when your board votes are having, or that you as a board are not having to have agenda items saying, yes, this account, send this letter, send this one. It's already done automatically based upon the time frames that you've established. You want to use your statutory remedies for managing delinquencies. Amenity restriction. If you're in a community that has amenities, you have a way of preventing access, whether it's through key fobs or something like that, or gate codes or something, and you can turn off their access to it. You have to go through the appropriate process of voting at a board meeting to suspend their amenity use rights, but that can be a successful way of managing your delinquencies. I know for large HOAs that have guards and gates, where you might have a dual entrance where you either, guests or vendors check in with the guards, and then the residents have automatic access through their barcodes or their key fobs or whatever, that some communities have voted to suspend their access through the gate. And as long as you do that appropriately and send them written notice, that now they're making them check through with the guard every time. That helps get those people back in line pretty quickly to pay their dues so that they can get their key fob access or their barcode going again. So be mindful of that. I would say the more the aggressive policy is, the more that you want to talk with your attorney, just to make sure that you're not running afoul of anything that's prohibited. I think the most extreme that I've seen for an HOA is where the HOA was responsible for irrigation of the lots, but that the owners were responsible for keeping their lots in a neat and clean condition. And they said, Ed, we can actually turn off the irrigation for that lot specifically. So then what's going to happen, their grass is going to get brown, and then we're going to fine them for not maintaining their grass. I don't know that I'd go so far. That might be going to a utility. I'd be careful of doing something like that. You certainly can't shut off utilities for a condo. You cannot, if the condo is otherwise providing for water or, even cable and internet, I'd be careful about doing that. That's a little bit of a gray area, but I've advised against that as a method of, enforcement. You can also suspend voting rights. I talked about that earlier, and then you can apply rent. I have some slides here about applying rent. If you've got an owner that's delinquent and they have a renter there, you can actually send out a demand letter to the renter and make them pay the rent directly to the association until the delinquency is satisfied. So I think that's why it's so important for your community, though, hey, do we have a process for making sure, do we know if units or properties are being rented? If so, maybe we want to put a rule in place. Even if we don't have approval rights, do we want to put a rule in place that says you need to notify us and give us a copy of the lease, for example? That helps you stay on top of who's renting, so that if there's a delinquency, you know who's there and you know how much the rent they're paying, so that you know how much you can expect you can make a demand on them for. The biggest thing for renters is that when we send that demand letter, if they don't pay us the rent, you can actually evict them. You have standing as an association to evict them. It's not always the best remedy, but it is something that at least puts some, teeth behind your ability. The reason I say it's not the best remedy is because once you evict the tenant, that doesn't really help you get paid as an association. All it does is it deprives the owner of getting a rental source, but they might just go out and rent it to the next person. And you have to go through the same thing with them. If you're getting that far and the renter's not paying and you're thinking about evicting, you're better off just going through the lien foreclosure route. All right, so the repair and rental of abandoned units, this is just for condos. Association has the ability to enter abandoned units to inspect and then make repairs, turn on utilities, or otherwise maintain, preserve, and protect the unit and the adjoining common elements. And you can treat it as an assessment against the property. So that was something that was put in place. There was a lot of abandoned units after the last housing crisis, in 08 through whatever it was through, 12 or 13. It took us to get through it with a lot of abandoned investor units. This helps provide so that you don't have to go through the whole expense of foreclosing and obtaining service, that you can actually enter it and then rent out and obtain a receiver to rent out the abandoned unit for the purposes of offsetting the delinquency. All right, so what happens if you have surplus funds? It includes all the excess monies retained by the association after deducting expenses. If a not-for-profit corporation and the surplus is not from a special assessment, funds cannot be returned to owners. What you typically do is provide it as a credit towards next year's assessments, or what I find associations doing is, even if they move it over as a surplus on the revenue side, that they might find a way to increase their reserves to match that, so that you're still keeping the reserve or the assessment amount similar. Sometimes it's an unanticipated surplus. Maybe it's from, whether it be delinquent payments that you weren't expecting, or there's all kind of limited issues where you might have a surplus in the year. It's unexpected income. Most associations don't like to have their assessments artificially dip for 1 year because their expenses are staying the same and then have them go up the next year. A lot of them will find a way to increase reserves or something to offset any type of surplus that you have. A special assessment surplus, upon completion of the specific purpose, the excess funds can be returned to the unit owners or applied as a credit. The latter is what usually happens, just because, again, it becomes tricky to try to refund special assessments. What if it's, do you refund it to the current owner? Do you refund it to the previous owner that may have sold when after the special assessment, or after the special assessment was levied, that they paid, so that becomes difficult. Mostly what they do, it's just like an operating surplus where they roll it in or they'll put it into a reserve account. Overview of reserves for condos. The purpose is for major repairs or replacements. You can use it. You can't really use it for other purposes unless you obtain a membership vote. Must be obtained by majority approval. That's for condos and for HOAs. Funds must be separate from other operating funds, so you can't commingle your reserves with your operating amounts. The required reserves for condos include the roof, pavement, painting, and any other item for which the deferred expense or replacement costs exceeds $10,000. Budget must include a fully funded reserve schedule. This kind of goes back, and I'll talk about reserve studies in a little bit, but Leah brought that up earlier. Really to know if you have fully funded reserves, I would say that you should have a reserve study done. That's a professional that you hire to make sure that say, yes, these are the components that you have. This is how much you should be funding it, so that when it comes to replace that you have all the amounts that you need for it. The pooling method versus the straight line method. Straight line method means that you have your required reserve components and that you're funding those, and you have separate accounts for each one, so that you know that you can't pull money from any other fund for other than their intended purpose. So let's say you have a roof reserve and it's $100,000, and now you're coming up and it's actually going to cost $125,000. When you have a straight line method, you're going to pull that $100,000 from the roof reserve, but you can't pull that extra $25,000 from the other reserve amounts unless you have a vote of the membership. So then what happens then is usually then you either have the vote of the membership or you have a special assessment that's passed to cover the difference. But then the other reserve amounts are still fully, whatever, they have their amounts, they haven't been touched yet. Pooled reserves means you're taking all of your required reserves and you're putting all the money into kind of one pot, so that as long as you're taking money out for a proper reserve item, it doesn't matter that maybe you thought that you would only need $100,000 for that. It's $125,000. As long as you have enough in the pooled account, it provides you with flexibility, so you don't have to have that vote of the membership. To go from straight line to pooled funding, you do need to have that one-time vote of the membership to kind of combine those amounts, because the amounts that were otherwise segregated can now be used for other than an intended purpose in the future. So you want to make sure that you have that vote. That's the biggest thing between pooled and straight line funding. Budgets may include reserve accounts for HOAs. It's not as statutorily required as it is for condos. The three ways to have reserves for HOAs are if the developer established them in the initial budget, then you have to keep on funding them. If the association through the board establishes them because they're required by the governing documents, or if the members vote to have reserves. Those are the three ways to have them. If you do have reserve accounts established, the funding is determined by a formula, must be maintained and funded in accordance with that formula, and it can be waived upon majority vote. If the reserve accounts are not established, or if you don't fully fund them, you have to have that membership approval, and there needs to be a disclosure requirement saying that, hey, failure to fully fund the reserves may result in a special assessment. Talked about the straight line versus the pooling method. Florida law requires that the reserve funding should be included at the fully funded level. Owners may vote to waive or reduce the funding level, but the budget must contain the fully funded amount. So what happens a lot of time maybe is the board at the budget meeting will, if they know that they want to have less than fully funded reserves, they'll put two budgets out, one with the fully funded reserves, one with the less than fully funded. You make a vote. And what I've always recommended is I make a motion to establish this budget with the less than fully funded reserves, but only to the extent that it receives subsequent membership approval at the required membership meeting. If such approval is not obtained, then the fully funded budget with the fully funded reserve shall go into effect. Something like that, where you have that at your budget meeting, then you have your subsequent membership meeting, so that if the vote doesn't, come in for the less than fully funded, you've already approved the fully funded reserve or budget with the reserve amounts. So the reserve schedule, what does that include? It recurs all the required deferred maintenance and capital expenditure items, the estimate of the useful life, the estimate of the remaining useful life, the estimate of the costs, the fund balance at the beginning of every year, and then the required funding for the budget year. Reserve studies. Florida law doesn't have a specific law about reserve studies, but part of the fiduciary responsibilities of the board, it's a good idea to obtain one. I have every 3 to 5 years. It could be every 2 to 4. It just depends on the nature of your community. The more frequently you have it, the more you're being efficient, where they might say, hey, you actually are underfunding this or you're overfunding it. You want to make sure that you're as efficient as possible so that you're not, either overfunding and you could be reducing your assessment amounts, or you don't want to be underfunding so that by the time you get there, you say, hey, I thought this was only going to be $100,000 project, but it looks like it's $200,000 and we don't have that amount of money. We should have been more fully funding our reserves as we went along. That's why the reserve studies are so important, to make sure you're kind of staying on track. All right, so that's what I have from the financial side. I'm just going to take a look at some questions if we have any budgeting questions here. Patrick says we have 2 special assessments coming up, one for roof replacement due to leaks and age, and the other one due to partial balcony failures. Our governing documents require consent of the owners for special assessments, but do not confine consent anywhere. How would you proceed to gain consent? If consent isn't required, what I typically recommend is sending out a proxy, Patrick, and having a limited proxy sent out, where you basically say yes or no, do you approve the special assessment for the following purposes? That would be. And if it doesn't say what threshold you need of members' consent, the default would be majority membership approval. I would want to look, and that would be a document specific question, just to make sure that we look at everything to see what the documents may require. But in terms of how you can obtain that consent, if it doesn't say that it can only be done in a meeting, you could either do by written consent, where you send it out, and once you obtain the necessary number of approvals, then that's okay. But most associations will have that proxy sent out and then try to call a meeting so that you can vote in person or by proxy. Glenn says, if our HOA reserves are overfunded, can we delay adding reserve money in any given year? Yeah, and I think that would be based upon a reserve study that's done that says, hey, you're actually overfunded for this next year. I don't think that you actually need to fund this because you're fully funded. Or I would just talk with your reserve analyst about it, and they might say, keep funding it this way, but then you can stop funding it on this year, or you can say, hey, can we just reduce this and spread it out more? I would just talk with your reserve analyst about it, but I think you've got some flexibility there, as long as you're continuing to maintain them in a fully funded manner. Jacqueline says, does 718 now allow condos to waive down the year-end report? I believe if you're talking about the financial reporting, you are allowed to do that. But you have to have majority membership approval in order to waive the financial reporting requirements. Allie asked a good question that comes up a lot. Can delinquencies discussed at board meetings name the delinquent owners or the units? Yes, you are able to do that. You're not, just by naming them, it doesn't mean that you're infringing on their privacy. It's at a board meeting. You have to be able to do your job as a board to be able to discuss this. As long as you don't start going in and obviously doing something, calling them deadbeats and harassing them and posting deadbeat notices, you're not going to have any problem with the Fair Debt or the Florida collection practices, the version of that from a collection standpoint. If there's an operating surplus to be carried over to the following year, how is that shown on the budget? Can there be a contingency line item on the budget? Again, be careful with that. I'd want to talk with your CPA about it, just from a standpoint of if it's taxable income, and that's more of a CPA question. But I believe what you typically do for surplus is that's on the income side, that you say, 2020 surplus for your 2021 budget. You plug that in so that then if you're having let's say you've got $1 million of expenses, just to use round numbers, but you have $100,000 surplus, you would put that in there as basically income carried over from the next year, so that now you have $900,000 of assessments. Now, if you want to have a contingency line item for maybe on an expense side, that might be possible to do. I know it gets a little bit tricky that you should only be budgeting for anticipated expenses, but that may be a way to offset that so that you keep your dues at the same level. Tanya says, has anyone used pooled cash flow calculation for reserves? Can pooling the reserves be done in combination with straight line calculation? And on the balance sheet, it just states capital expenditures and deferred maintenance. So I think if I understand the question right, in terms of combination pooling, the way that it comes up the most is, Ed, we're not going to be able to obtain the necessary membership approval to change all of our straight line reserves to pooled. What some of them have done is they will start creating a pooled reserve moving forward, but then and kind of use up the existing straight line funding so that they don't have to have membership approval. They're not taking those straight line reserves and using them for other than their intended purpose, but moving forward, they start funding them on a pooled level, and you kind of have the dual sources of money for that reserve item. That I hope that answers your question there. If your reserves are pooled, then why would you specially assess versus take money from another reserve? That's a great question. So if you do have pooled reserves, that a lot of times offsets the ability to, or the requirement to have a special assessment, because now you've got this partner. So if you have, let's say you have 5 reserve items, and each one you have earmarked 100,000 for each one, so you have $500,000 in your pooled reserve. If you have an expense for a reserve item that's less than 500,000, that's where you have that flexibility to pull it from there, and you don't have to necessarily specially assess for it. Bert asked a question going back to and we have official records coming up. In a multi-condominium association, who's responsible and accountable for maintenance of the official records? If it's a multi-condominium and you have one association for multiple condominiums, it would be the secretary for that multi-condominium that would have the obligation, and you typically then have that through the management company. Great. Okay, thanks, Tanya. Jerry says, if it's pooled reserves, as monies are taken from one account, then does the line taken from need a higher funding rate going forward? That's where, especially, you want to make sure that when you have your reserve studies done, you say, hey, we were budgeting on this, but this expense came up or was higher than what we anticipated. They'll make sure to properly, the biggest thing for pooled reserves, you have enough money for that year, that for the items that are going to be coming up, that you make sure you have enough money in your pooled account for each year that comes up. So if you've taken from one thing and maybe it was more than what you thought it would be, I would just double check and make sure with your reserve analyst that, hey, are we good going forward? Do you need to tweak this because we had to take out more than what we had budgeted for this reserve item? Another question is, we have a line item for legal in our deferred maintenance. Can we use deferred maintenance to pay excess legal expenses? If you're an HOA and you have kind of a reserve account, reserves, usually you want to try to leave those for unanticipated, like capital expenditures or deferred maintenance items, and really legal expenses aren't necessarily that, but you do have more flexibility as an HOA, especially, to have like I would call it like an emergency or rainy day reserve fund. You just want to make sure that you properly define that and then when you can use those monies. So I know reserve analysts always get a little bit squirmish when you have reserve accounts for something that's not like an actual component that they can look at and say, here's the useful life, here's the remaining useful life, and how much you should be funding for it. But if you have authority to do it and you clearly state it in the meeting where you set it up, I think you'll be okay with it. All right, so we're going to jump into official records, and I'll try to get us through quickly, everyone. Thank you all. So for records maintenance, the official records are open for inspection by any association member or authorized representative at all reasonable times. The right to inspect includes the right to make copies at a reasonable expense. They shall be maintained within the state. Records shall be made available to owners within 10 working days of receiving a written request sent to the board of the designee. This third bullet point is something that comes up a lot. Sometimes owners will send an email saying, I want copies of the following. That doesn't necessarily trigger, and I've had an arbitration case where I actually had to litigate this and we prevailed, that says that that's not actually an official records inspection request. It's a request for copies that doesn't trigger the 10-day requirement. Now, I'm always conservative on that because arbitrators change. You don't know how they're going to handle something. If an owner does that, what I would say is, hey, we can make those available for you, but you need to restate this as a request to inspect the official records. And once we receive that, we will make the records available within 10 working days. That way you're kind of giving them information of what they need to trigger that to be able to view it. Even some associations might say, hey, we're treating this as a request to inspect. We'll make these records available for you, but you're now required as an association to go and find documents and then mail them or email them to them. So these are some of the records that have to be permanently maintained for condos, and for HOAs at 7 years. Copies of the plans, permits, warranties, and other items provided by the developer. Copies of the recorded governing documents, the minutes, and then the accounting records. Then you also have to maintain the current roster and the mailing addresses, voting certifications, current insurance policies, copy of the management agreement, lease, and other contracts, bills of sale or transfer for all property owned by the association, and all other. The last thing is all other written records related to operation. That's the catch-all. That can be a bunch of different things, whether it's emails potentially, whether it's a security guard log, whether it's a report from a committee, all that stuff could be other written records related to operation. For condos, some specifics, ballots, sign-in sheets, and voting proxies are only have to be maintained for 1 year. All rental records have to be maintained. Copy if there's a question and answer sheet that condos have to have by statute. It has to be updated annually. That needs to be made available for inspection. Copy of the inspection report. I talked about that earlier about you have to have that done and make sure you're properly insured. That needs to be provided, maintained as provided in the statute. And then this is the question about electronic voting for condos. You have to keep electronic records related to voting. Doesn't actually have that for HOAs. So that's still up in the air. For any of you condos, this is very detailed, but if any of you, and if this was in person, I would ask you to raise your hand if you're in a condo that has more than 150 units. Since I can't see you, although there is a raise your hand function here. So if you want to do that, just for my own sake, just for entertainment value. It's, if you do have, okay, so I see 3 people raising their hands. Thank you. If you have more than 150 units, as of January of 19, you do have to have a website, and these are the records that have to be made available on the website. For HOAs, I'd be mindful of this because this is one of those things that I could see being amended in the HOA Act and added to that as a statutory requirement. But as of right now, it's only the case for these large condos. I'd also say this for condos that are less than 150 units, that this may apply at some point in the future. There may be a legislative change there. I'm not going to read through all the documents. You can take a look at that when I send out the attachment later. So what are records that aren't accessible to owners? Any record protected by the attorney-client privilege. My disclaimer I always give on that is if you do get an opinion from an attorney, don't start reading that opinion at an open meeting. There is an arbitration case where somebody then asked for a copy of that opinion letter. The board said, no, it's privileged. And the arbitrator said, once you start reading from it, you've waived any type of attorney-client privilege. I'm not saying 100% agree with that, but I would just be careful about reading from an attorney-client, or overly summarizing what an attorney opinion was, because if it's based on a written opinion, you may have waived your ability to keep that as a protected record. So just be careful of that. Any information obtained in connection with the sale or other transfer of a unit, personnel records, medical records, electronic security passwords, any software and operating system access information, those are all records that aren't accessible. Other protected information are like social security numbers, driver's license numbers, credit card numbers that you may obtain, email addresses, unless owners opt in, email addresses are protected. Telephone numbers, fax numbers, emergency contact information, unless owners opt in to provide some of this stuff. Statutes have been clarified that all telephone numbers may be included in a directory if they're provided to the association, although the owner may choose to opt out of it. But email addresses can only be used if they actually opt in. So just because you have somebody's email address doesn't mean that it's open for inspection or that you can use it as a means of communication in lieu of mailing. They have to actually opt into it. So just be careful of that too. I know a lot of boards that might say, hey, we're really trying to get people to accept notification of official documents or meeting notices via email. Please sign this opt-in form so that we can have it on record, and then just have like a one-page sheet that they sign off and identify their unit number or their property address, and that they're consenting until further notice to receive notification via email. That's a nice way to have it. Then you keep that on file so that if anybody challenges you later, you can point back to where they signed it. All right, so inspection of records. We talked about it a little bit before, but the official records of the association are open to inspection by any member or authorized representative at all reasonable times. The association must respond to a records inspection request within 10 business days. This was updated as of July of 18 for condos. It used to be 5 business days. If you don't do it by that date, there's a rebuttable presumption that the association has willfully violated it, and owners can get $50 a day past the 10 days, up to $500, unless they can prove higher damages. I've never seen that happen too much. My only hypothetical where I could see it is for maybe if in connection with the sale, the buyer was interested in obtaining some official records. And so the seller said, hey, I would like a copy of the following records that I can provide to the buyer. If the association doesn't allow an opportunity to inspect the records within the reasonable time, maybe the buyer has the sale fall through and now the owner goes through and they have to sell it for a lower amount. They could say potentially that the difference in sale price might be the damages that they've suffered. Now, there could be a whole host of other reasons why that sale fell through, but I'm just trying to give a real life example of why there is some teeth to this and why we just need to make sure. The main thing, what usually happens is you get these in, you'll respond back and say, we've received your request. The records are available for inspection at the office between this time on these dates. And that's all you really have to do. And then it's up to them to make sure that they coordinate it with you. Doesn't mean that you have to make them available at all times whenever the owner wants to show up. That's not what's required. The last thing here is that the association is not responsible for the use or misuse of information provided to an association member or the authorized representative pursuant to the compliance requirements. So in other words, I've seen some instances where it's kind of an owner that is in a contentious issue with a neighbor, or they're just adversarial, and that one of the neighbors is making an official records inspection request, and the board has said, Ed, we know what they're going to do with this. They're going to try to embarrass this person or something. I don't know, whatever the reason for the records might be. Our response is, unfortunately, we're not responsible, but we have to make these records available. You can't say we're withholding them from you because we're worried about what you're going to do with them. You have to make them available to the owner. All right, so just some additional legal updates. Emotional support animals. This especially is probably applicable for our condos in here. And HOAs if you're a townhome, or maybe even if you're an HOA that might have pet restrictions. There's a new Florida statute. It's 720.27 that's and it's added to the Fair Housing Act. It heavily borrows from the Fair Housing Act. It basically says that it's unlawful to discriminate based upon let me see here. Unlawful to discriminate in the provision of housing to a person with a disability or disability-related need for, and who has at any time obtains an emotional support animal. So an emotional support animal is defined as an animal that does not require training to do work, perform tasks, provide assistance, or provide therapeutic emotional support by virtue of its presence, which alleviates one or more identified symptoms or effects of a person's disability. Let's see here. Documentation may not be prepared by a healthcare practitioner whose exclusive service is to prepare documentation in exchange for a fee. In other words, they're trying to crack down a little bit on these specialists that are just trying to, make a buck to provide these letters for emotional support animals. The requirement that if healthcare practitioner is out of state must have provided in-person care or services on at least one occasion. So the same thing is that even if it's a doctor that has other business aside from writing these letters, for example, if they're out of state, the person that's trying to use them has to have met with them in person at least once. The landlord, I put association because they just use the word landlord, may also require proof of compliance with state and local licensing and vaccination requirements. And then there are criminal penalties for fraudulent, false or fraudulent proof of need for emotional support animals. It's second degree misdemeanor. Now, how do you prove that? It might be difficult, but at least it's encouraging from an association standpoint, because I've had to deal with a lot of these issues where I can tell that they're probably abusing the process, that at least they recognize that they're trying to crack down on the use of that. Communities with pet restrictions are strongly encouraged to adopt procedures for requesting accommodation in the form of an emotional support animal. And then remember that a pet and a proper support animal are not the same thing. So I've had communities that will say, well, Ed, we're a no pet facility, therefore we don't have to allow a support animal. Well, no, a support animal is not the same thing as a pet. It's an accommodation. It's just like if an owner that has a wheelchair needs to have a ramp to get to their unit, that's an accommodation request. It's the same thing as that. So we have to be very careful with it. If you ever receive any one of these requests, you want to be very careful about how you proceed. I'm involved with one right now where we're trying to obtain information, but the owner has filed a complaint with the state through the Florida Commission on Human Rights for basically a HUD violation, arguing that we haven't approved it. It's not actually on a support animal issue. It's on another FHA, a reasonable accommodation request. But the biggest thing that you can do is say that you are engaging in the interactive process to try to obtain information, because you're entitled to obtain information on some of this stuff before approving it, before you actually deny something. So take these requests very seriously, get with your attorney on it, because it's very easy for an owner or a tenant to file a complaint and not have to actually spend any money, because these administrative agencies will investigate it on their behalf. And then the association is the one that has to spend money defending itself. So just be very careful with that. Some additional updates, law enforcement vehicles. It just includes a provision which would preclude a HOA or a condo from prohibiting a law enforcement officer from parking his or her assigned law enforcement vehicle in certain areas. Have common sense. If you have law enforcement in your community, you probably want them on your side anyways. Try not to come down on them for parking issues. That's my biggest takeaway. You're allowed to have fireworks on designated holidays now, New Year's Day, Independence Day, and New Year's Eve, but you can have prohibition against use of fireworks in the governing documents for other days. So just there's some latitude for allowing fireworks, and that's new as of this year, actually. Fining and suspension. I kind of brought this up now. There was an amendment a couple of years ago regarding the fact that a fine is due within 5 days of the committee hearing. But I wanted to use this as a very quick kind of overview of the fining process. If there's a violation of your governing documents, the association has the ability to fine, and may be limited in the amounts pursuant to your governing documents. So you do need to look at that. But the general rule is that you can fine up to $100 a day, not to exceed $1,000 in the aggregate. For HOAs, you can deviate from those amounts, higher than those amounts, if you have authority in your governing documents. But it's the board that imposes the fine, but it cannot be collected unless it's approved by a committee that's made up of at least 3 members that aren't a board member. They're not a board member, an officer, or their spouses, or an employee of the association. So it's kind of a completely impartial, at least separate from the board and officer committee. That committee, before you get in front of them, if you impose a fine, you have to give the owner or the violating party at least a 14-day notice, and the date and time of the committee meeting, and their opportunity to show up and present evidence as to why the fine shouldn't be upheld. Once that fine is approved by that committee, it's due within 5 days of the committee's decision. It says within the date of the committee meeting, and that you have to provide them written notice. I would just say, if you get your notice out 2 days after the committee meeting, it's 5 days from the date of the notice rather than from the committee meeting itself, right? Get with your management company and your attorney on developing a process for what your fining and enforcement process is going to be, whether you're going to provide a certain number of courtesy notices when the fine can start for the board to impose it, because that's not really defined in the statute. I think there's a little bit of latitude there for communities, but I think having a fining and enforcement process, a policy, is very important for communities. We've done that for a bunch of communities that we've worked with, and every community is a little bit different. Some of them might want to impose fines based upon the type of violation. Other might treat it as the same fine regardless of the type of violation, but that the fine amount goes up if it's repeated within a certain period of time. There's some flexibility there, and I think I would just get with your manager and with your attorney to establish a policy for that. And that way you can provide it to the owners. Again, the big theme that you've heard from me this morning is uniform policy, letting people know what it's going to be so that you're treating it on an objective basis rather than make it seem like you're making things up as you go. That's a big thing that helps you and provides you with success as a board member, is to have established policies and procedures that you can show that you're following. Some condominium updates. I actually just had this question come up regarding alterations, but electric vehicle charging stations for your condos. If somebody wants to put in an electric vehicle charging station, normally that would be a material alteration that would require membership approval. They've carved it out to say that you don't have to obtain membership approval, but you have to meet all of these requirements in the slide here, which means that you have to comply with safety requirements, building, that you're consistent with the applicable building codes and safety standards. You have to comply with architectural standards adopted by the association, have a duly licensed and registered electrical contractor or engineer, provide a certificate of insurance, reimburse the association for the actual cost of any increased premium, that the electricity charges must be separately metered, and that the cost of installation, operating, maintenance, repair, and removal is the responsibility of the owner. So it's all to say, like, they want to allow it and not have it be based upon a member vote, but the owner is really responsible for everything in terms of the safety of it, the construction of it, and paying for it, and all the electrical charges, of course. Some HOA updates from the last couple of years. One thing is that when you amend your governing documents as an HOA, you have to show that underlining as the new language and strike through is what you're taking out. We've already done that. Most attorneys have already done that anyways when you do document amendments, but now it's the requirement. And then notices under section 72306, that's the section regarding membership meetings, must be mailed or delivered to the parcel owner's mailing address on the property appraiser's website. This is important because it's creating an obligation now on the association to look whenever they're doing a mail out for a member meeting, to look to the property appraiser, even if the owner may not have updated their mailing address. So I know that that's frustrating. You really should talk with your management company because usually the board's not involved and it's a management company. And I know Lee and I, we've spoke about this before about being mindful of it. And, I could imagine the time and expense that might be for like a 1,000+ member master association and having to comply with this, but it is a requirement now. And it's something that you should be mindful of for the association.
This
Go ahead,
is
Lee.
awful.
I know.
I mean, we, again, we manage communities that have 6,000 homes, and you can only imagine, I don't even have to say it out loud, but it is so daunting and so cumbersome administratively. This is another one of those things that legislatively we need to lobby against this, because if I give a new address to my management company because I'm going up north for 6 months, this is crazy.
Right.
Our software allows us to put in 2 addresses, but at the end of the day, it's double mailing cost. We can't administratively keep up with this. It's impossible.
I think it's the time effort of actually having to check the property appraiser's website. Even if they gave you an updated address, you still have to check to make sure that they didn't change it still with the property appraiser, like. And
then you have a mad owner because they didn't get a notification, and they're like, I called you and told you. We're like, well, but here you go. So, yep. I mean, this is just untenable, and it's just not manageable. And I can tell you mistakes are going to get made through no fault of anybody.
Sure. Yep. So something to be mindful of, and then obviously lobbying. And then whenever there is legislation, if it is going to go through, there's always lobbying efforts. Homeowners can call their representatives, based upon where they're located, to let them know why they should be approving this. And, so we always try to get the word out if we can get it into some proposed legislation.
Yep, absolutely.
Yep. All right. Well, finishing out, just another change was for the assessment payments. If there's a partial payment, they changed the statute to say that even if an owner tries to be sneaky and put a restrictive notation saying, I know I owe $1,000, but this $200 check, if you cash it, it's payment in full, that doesn't fly anymore. So they closed that loophole. The Marketable Record Title Act. Let me say again, if anybody can raise their hand, if you're in an HOA, not a condo, but if you're an HOA that is around 25 to 30 years old or not, or maybe older than that. Because if you are, so I see a couple of like 3, 5, 6, we got a lot of people in here. You're subject to the Marketable Record Titles Act. Maybe you've gone through this already, but the main thing is that your covenants can expire if you don't take actions to preserve them within 30 years. Now, the 30 years is The conservative date is to look at when those covenants were recorded. That's easy to know of your date. And as long as you preserve it before that, you're not going to have any issues. Technically, it runs for each parcel. So you might have some parcels that maybe were initially sold more than 30 years ago, but a great majority weren't. I always say just look at the recording date of the initial covenants. And if you preserve them before then, you're going to be fine. But it is something to look at. The only change to that is that it made it an easier process for preserving them, and then also applied it to property owners associations that might not be a residential HOA. It might be that mixed commercial like we talked about earlier, or a completely commercial property owners association that have covenants that now can be subject to the Marketable Record Title Act, just like the residential HOAs have been able to. So that's the big thing. If you're in a community though, and if you're not sure, check right away with your management company and check with your attorney. Preservation's an easy process. It doesn't cost that much. It's just, it's a couple forms promulgated by the attorney and then is approved at a board meeting. If you miss the time period and your covenants expire, then it's called revitalization, which is I usually say it's in the thousands of dollars, because now you have to have member vote, has to go up to the state for approval, needs to be recorded. It's a much more expensive process than just preserving them. All right, so in summary, as board members, you have the fiduciary obligation to set aside personal agenda and put the association first. You want to stay focused on the job at hand, be familiar with the governing documents, know your duties and perform them competently, set goals and establish values, and then obtain the necessary education, which you all have done this morning by listening. We're at 2 hours and 20 minutes, but with a lot of good questions. And I appreciate you, staying in here with me and attending this. I'm going to put this onto my contact information. If my firm can be of assistance, of course, we'll be happy to help out. And just so you have our contact information, we do represent associations throughout the state, but really I want to take some time now just to answer any questions that we might still have in here. Let me see. I'm going to go back to some questions for later. Does remodeling of a common area belong in the reserves? I would say if that's for like a capital improvement, if it's going to cost more than $10,000 for that, and you know that it's going to be a future expense, that would be a proper reserve item. You want to look at what the requirements are in your governing documents for reserve funding and everything, but I could see remodeling of that. If that's optional, if that's more of an aesthetic thing that's not required because something's failing, that might not be a reserve item unless you have the authority, kind of broad authority to establish that, then I think that would be okay. So it's going to be document specific, but I could see that being done. Yes, we do work in the South Brevard County area, Jerry. If you want to reach out to us, be happy to help out. Once reserves are established, may they be amended at the budget meeting without a member vote? So we addressed that. That's a great question. It has to be, if you're going to do anything less than fully funding of reserves, that requires membership approval to do that. So the board in no instance can have less than fully funded reserves unless the members approve it. Robert says, let's see, I'm the president of an HOA. To plan for board meetings, we have a board working session a week before our board meetings, and we notice and invite all owners to attend the working session. Okay, that sounds good. We make no official decisions at the meeting, but all board members attend. We very seldom have homeowners attend, but they're always appropriately invited. Prior boards always use the excuse of not being prepared to conduct an efficient board meeting, that under the sunshine laws, they were not allowed to get together to plan. I think our approach is both healthy and legal. Any thoughts, Bob? I'm applauding you right now. That's a great approach that you have. I hope you're still on so you can hear me applauding you, because what you're doing is you're doing everything open so that members can attend it. And I see people raising their hands. I'm not sure if everybody can see that. I think that's other people clapping for you right now. So yes, that's the great thing to do. I see that, the most common thing that I see for workshop is kind of getting around, well, we have our budget meeting, Ed, but we have a workshop, but we don't really have owners attended. I always say, if you're ever calling anything a workshop and the majority of the directors are there, you have a quorum, which means that you have to have it as a notice meeting. So if you want to get around that and maybe have some more frank discussion that doesn't involve the entire board, have less than a quorum of the board there. So, but for what you're saying, Bob, I think that it's healthy and it's definitely legal. So I think that's a great approach. Bert says, do records need to be maintained in hard copy or is digital acceptable? The statute does say that you can either have it by hard copy or if you maintain an electronic format and that people can have access to, there's no requirement that you have them available via hard copy. And I honestly, I'd recommend a lot of associations, if you can get in the habit, and Lee, maybe if you want to jump back in here real quick, from a management perspective, I think that it's a good approach to try to be as electronic as possible. I think it's just keeping up with it. As once you start doing it, then I think that makes it a lot easier. If you have a website, then these official records inspections are, hey, everything we have is already on the website. If you have a website, here's your login information. We don't have anything that you don't otherwise have available here. Lee, what do you think about that?
Yes, because you can really get sucked into the vortex if you get an owner that gets sideways and they just inundate you with records request. It can become very cumbersome, and there's no way for the association to recover the cost. It's challenging for the management company because you have to sit with somebody. And so anything that we can do through the websites, we have an advantage with Vesta, with our Vesta Vantage Pro program, where every owner has access not only to all the official records, but also to their own information within our accounting database, where they can go in and update their own personal information and look at any compliance issues or violations or ARC requests. So, we're trying to keep up as best we can with the technology, and it's just more efficient and effective all the way around.
Yeah, perfect.
Yep.
Let's see, if a member sends a global email without authorization, how should this be handled? You can't really, if a member, I guess if that's a board member, you can't really prevent board members, but you can maybe state something that this isn't necessarily an action of the board. It's hard to have like an authorization process or anything. If members are sending emails, I guess maybe if this is a member sending a global email, maybe to the entire membership, that they obtain their email address. What I've seen is when members try to disrupt the affairs, or if they're saying something that's untrue about the board or about an action taken, that's when I've seen sometimes the board send out kind of a cease and desist letter to that member saying, hey, you are affecting the operation of the association. You may be interfering with the operation that could give rise to a cause of action. Please stop doing that. You may want to email everybody else and say, anything from this person is not an official communication. This is the official communication, and you're welcome, of course, to attend the meetings. I hope that helps answer your question, Jerry, there. I know that can be a problem sometimes where homeowners, or they create, ABC Association Committee at gmail.com, and it makes it look like an official communication when in fact it's not. That may require correcting from the board on some level, or like a Facebook page that looks like it's an official one, but actually isn't. So those issues come up a lot. How many support animals can a person have? One lady, this has not been decided yet, and we would love to have some clarification, but I would think that a healthcare provider would have to have a very good reason for saying why more than one animal is absolutely is necessary to help alleviate a major life activity, and why two are more important than one. So we don't have that clarification yet for the person that asked that question. It is something that you can push back on, but then if they kind of stand up for the owner and give a form letter that seems to check the box, then it's up to the association to decide if they're going to accept it or not. And it's still an uphill battle for associations on support animal requests. So we don't have there's nothing though out there that says that one person gets one support animal. There's nothing like that right now. Linda asks, what documentation is required to provide to prove an emotional support animal? Is the type of animal defined? No, but you can't have a dangerous animal. I always give you an example of, like, just because somebody has a pet tiger doesn't mean that they get a tiger as a support animal, right? If it's an inherently dangerous animal, now I'd be careful though on breed restrictions, because that's been kind of kicked back, that's saying you can't say we're not allowing this support animal because it's a pit bull and we don't allow pit bulls in here. You really have to see if that animal becomes dangerous, and then you can require it to be removed if you can document it. But I'd be careful about that. Documentation, though, the big thing is that you can't ask for what the disability is that the person suffers from, but you can ask for what is the major life activity that is affected by the disability, and then what is the connection between that and the emotional support animal, or whatever the accommodation is, if it's just a broad accommodation request. It has to be by a treating healthcare provider. And then, like I said, Florida has kind of updated to say that trying to eliminate, there's an operation out of California that says, for $99.99, we can get you a letter to get you a support animal, and you just need to call us and we'll get you a letter within 5 minutes or something. There is something now that says that you can't have it from there, or even if that person is treating them, that person has to meet with them in person at least once for it to be valid. So there is a little bit extra teeth of what we can look for and require. Colleen has a COVID question. Should the HOA make members aware of outbreaks within the neighborhood, not using names, but as awareness? That's a great question. There's not a perfect answer on that. You know, it's almost once you start doing that, you almost have created an obligation to do that whenever you're aware of an outbreak in the future. I 100% agree, though, that you should not be in any way providing names. And even if you're asked, you do not provide that information. But it's up to that owner to consent, or even if that owner says, please don't use my name, but please say that I was at the pool area, you know, the last 2 days, so that people who were there can be aware of it, or something like that. If you start doing it, it just goes down the path potentially. And again, we don't know how this is going to play out, but just, I would say, if you are going to do that as a community notice, that you prepare to do it once you become aware of it going forward. Maybe put a disclaimer that says that we will only provide these notifications in the future when we are made aware of it, you know, firsthand, or something like that. So that way, if there's rumors about it, you don't have to provide it. Somebody has to tell you, or that you have firsthand knowledge, or something along those lines. What options, Colleen says, what options are available when people do not pay their fines? That's a great question. For HOAs, if a fine reaches 1,000 or more, there's an argument that you can lien the property for it. I'm always hesitant to do that unless there's very supporting language, like good supporting language in the documents, that you can treat an unpaid fine like an unpaid assessment. Without that, you can go through a small claims court, or if they also haven't corrected the violation, for HOAs, you go through mediation and you say that the things that we're mediating over are, you haven't corrected the violation and you haven't paid the fine. For condos, you don't go through mediation. You actually go through arbitration. And the two things you're saying are, we need an order for them to correct the violation and to pay us the fine amount. So I teach a whole 1-hour class on fining and enforcement, and it's a lot, but I hope that kind of provides you with a little bit of a glimpse of like the enforcement process after the fact. Thank you, Patrick. Thank you, everybody else. Let's see if we have, I think there's one more question. Is the Florida Support Animal Law retroactive? Are cards issued prior to the law valid, like ESA cards? There's really no thing as an ESA card. That's another marketing thing where this is a certified animal. What you have to have is something, if the disability is not readily apparent and what the major life activity is, then, you know, of course, if somebody's blind, for example, that's the disability. And then if they have a seeing eye dog, you can't really ask for much more. You can't really ask for any information than that. But if it's not readily apparent, then you can require that information. And just because they say, you know, here's a card that I get, it's a registered emotional support animal, there's no such thing as a registered emotional support animal. It's only under the ADA that you can have a service animal that has received training, that that you have to allow it if for a disability, and if the disability is readily apparent and all that. But there's nothing for ESA for emotional support animals. So you can still require documentation from a treating healthcare provider. And now with the Florida law, there's a little bit more tools that you can use to, require additional information there. All right, well, that's all the questions that we have. Thank you all very much. Thank you, Lee, and for everybody from Vesta. If we can provide any further information, we will be sending out I think what I'm just going to do in the future for these when you attend it is Nanny from our office, one of my administrative assistants, will be sending out in the next couple of days your certificate for everybody that registered. And then we'll send a copy of the PDF of the PowerPoint. And then I know that Vesta will make everybody aware of when the recording is going to be available.
Absolutely. Ed, thank you as usual. Great job. There's a lot of information to cover. If anybody wants to reach out to me, I can be reached at lstokes@vestapropertyservices.com. I appreciate every one of you for the time that you've spent this morning. And I hope everybody has a happy and healthy Thanksgiving.
Thanks, Lee. Thanks, everyone. Have a good weekend.
Bye-bye.